Welcome everyone. Welcome everyone. Welcome everyone. Let me hope you have a good morning. It is the 29th of this very month, like they said. Dr. Kizza Besigye, he had to come back to the court. Jukira last time Owasembo Kujawan, Dr. Besigye, Omukisa Ogwaliwo nti state oba prosecution side yali egamba nti baagala kuba nti bagenda mu maaso n'omusango guno olw'ensonga bakola PW abagimanyi obulungi production of warrant bakujjayo eruzira ne babeera nga bakuleeterawo mu kooti. So ensonga ezo zonna twaziraba nga tezasoboka ku olwo kubeerawo, naye embeera still yatambula mpola mpola nebeera nga ekulaga nti Dr. Kizza Besigye balooya be baasituka bonna ne beekandaga, bonna baasituka. Yes, tewaliwo kuwananda kulala oba tewaliwo kulowooza kulala in the fact of thinking about yes, Ingrid is around. Mbadde nkyakunyonyola muganda wange nti ensonga zino zonna bwe zaatambula zaatambulira ddala okubeera nga buli muntu yeewuunya amateeka engeri gye gayinza okuba nga gakwatibwamu, buli muntu nga yeewuunya ensonga zino engeri gye zikwatiddwamu olw'ensonga nti tewaliiwo muntu ayinza kuyimirira nga Dr. Kizza Besigye bwe twamulaba bwe yayimirira n'agamba nti abantu bannamateeka bange tebalina instructions. They do not have any instruction of standing there for Dr. Kizza Besigye. So the issue was after the lawyers of Dr. Kizza Besigye standing up, going outside of the court, kasita bayimirira ne bagamba nti nedda wano tetugenda kuyimirira kubeera nga tuwolereza omuntu waffe. Ekyaddako oba embeera eyaddawaawo kwe kubeera nga omulamuzi alagira state n'agigamba nti okusinziira nti nno applicant avuddeyo oba A1 avuddeyo n'agamba nti tagenda kubanga obanga awadde instructions balooya be, n'agamba nti tukikomyewo, omusango guno gukomewo ennaku z'omwezi nga 29, ennaku z'omwezi ze baayogerako. Yes, okubanga bakomawo, naye otherwise it was merciful from the court, you can say, oba omulamuzi ayinza okuba nga yali wakisa kubanga omulamuzi omulala yenna awo aba asobola okuzza oba aba asobola okugenda mu maaso n'omusango, naye yakitunuulira ng'alabira ddala nti abamu bagamba abamu mbu bino byasi byange bagamba nti omulamuzi kwolwo ne caayi yamulema okunywa olw'okuba nti nno balooya basituse ne bafuluma ne bagenda. So bwe tunyumbanga tunyumyanyumyamu mpola mpola, you can as well tell me where you watching us from, but in a few minutes tugenda kubanga tutandika kooti eno ye Heavy Media. Subscribe to this channel tubeerenga ekintu tukikwasaganyiza ddala bulungi. I'm yours truly Musa, Heavy Heart, osobola okumpita MC Heavy Heart, osobola okumpita Musa, osobola okumpita Heavy Media. Ekintu tuba tukikwasaganyiza ddala bulungi nnyo mpola mpola. Kasita olaba uniform ez'ebibombola, uniform abazisinga obulungi muzimanyi bulungi nnyo. Omukyalo oyo gwe mulaba wabweru, omukyalo oyo mumulaba wabweru, oyo y'omu ku batambuliza ddala Dr. Kizza Besigye, ne babeera nga bamuleeta mu kooti oba ne babeera nga bamuleeta wawalina okuba nga atuukira. So the narration is so long here and we shall be giving you bit by bit of this court. So just stay here. Ekintu tubeere nga tukikwasaganyiza ddala bulungi. You are live on the Heavy Media and we are streaming live here on the Heavy Media. So just keep calm. Tubeere nga ekintu tukitambuliza ddala bulungi maridadi sana. Bakanso bo wenjogerera batandise dda okuba nga batuuka, era ndabira ddala nga bakanso waneeno bali mu numbers weziri ez'abakanso, yadde nga Lord Mayor alabika nga akyalimu kubanga ateekateeka wano na wali the other side of the legal team of the state. They have not yet come here. The side of Billy Vumbuka and the others, they have not yet come. The state, basically, you never know, it may not be Billy Vumbuka for this time. Ate mulala nnyo n'abanga yagenda okujja, so you never know for this time around who is coming around, who are we going to be with today in today's court. So you can come around. Subscribe to the channel. Make sure you subscribe. Make sure you subscribe to the channel. It is the Heavy Media doing this like never before. It is the Heavy Media doing this like never before. Dr. Kizza, Besigye Hajji, obedi, lutale, Captain Dennis Olla. Wenjogera nti bannamateeka ba Captain Dennis Olla bo bazze. We're talking right now. Ingrid, the Deputy Lord Mayor, is inside right now. The Deputy Lord Mayor is coming inside right now. The Deputy Lord Mayor is there for you. Ingrid Doreen Nyanjura is there for you. He has just arrived right now. Doreen Nyanjura, she has just arrived right now, as you see. She has just arrived right now. The Deputy Lord Mayor. I think, as you've seen, Ingrid, the Deputy Lord Mayor, she's already here. Everyone is getting ready for the court, and we hope if you see Ingrid right now, if you see Ingrid Omanya, Ntine Lord Mayor naye ali mu kkubo, subscribing, to liking, no commenting, ekintu tubeere nga tukikwasaganya. Subscribing, ekintu tubeere nga tukikwasaganyiza ddala bulungi nnyo. It is a Heavy Media. Oli ku Heavy Media, otambulira ku Heavy Media, otukyali era nga ate ensonga zonna ozitambuza ddala bulungi nnyo. Subscribe to the channel, like and comment. We'll make it happen in this beautiful morning. It is a Thursday morning. It is going to happen. A lot is going to happen today. A lot is going to transpire today in today's court. So let's be here and we'll make it happen, ladies and gentlemen. Omwana alese bakanyama wano leero tayagala bamukwatako. Omuvubuka oyo gw'olaba ayambadde gaalubindi omu ku be basinga okwagala okukwata waneeno mu kkooti ya Besigye. Leero alese security. Olwaleero alese security. Abo boolaba mu gaalubindi, oyo gw'olaba mu gaalubindi bwe bamukuba security we. Be bamukuba security abaleese. Sajja security agiye, security agireetedde ddala wano. Oyo gwe mulaba oyo ayogera n'afande aleese security. Agamba leero teri mukwata. Leero teri mukwata. Anti omanyi waneeno wabaawo firimu ebiseera ebisinga. Kati security eyo gy'olaba, omwana oyo abantu abo boolaba benkulagaawo abaleese. Kyonna ekijja agamba ekijja kijja simbula embalaasi. Tugenda bawulira olwaleero. Tujja bawulira olwaleero bakanyama baabo. Kale ffe tulinze Dr. Kizza Besigye, wenjogerera Dr. Kizza Besigye dakiika ntono nnyo agenda bbanga atwegattako wemba tunudde wabweru ndabira ddala abakulu Kenny Luchams the man mulaba nga naye atuuse waneeno ogenda kubanga omulaba ndaba agenze kubanga ate abuuzaako ku Dr. Kizza Besigye ndaba Aaron Kizza abamu kummwe nga mugamba nti oyo ye looya wammwe abantu abawansi kugamba Aaron Kizza yafuuka wammwe naye mu nyumba ayingidde oba mu kooti mwali nnyo so we are waiting just keep waiting. Okay, it is going to be just keep waiting ekintu nga tubeera tukikwasaganya mpola just subscribe like and comment tubeere nga tutambulira ddala ffenna mpola ensonga osobola okuba nga okitegeera ddala bulungi nnyo. It is the heavy media kugambye olwaleero byakwetegeka omuntu bwakulumba kimafiya naawe olina okujja ng'oze kimafiya so waneeno kyendaba abaana bazze kimafiya naye kale katubalinde. I'm just informing you. Nze wano tewaliwo nawe bagondi babeerako. I'm just informing you my brother to get to know nti kubanga story nze nagimanya nga tennaba nabeerawo nti abaana bagenda kujja kimafiya so we are not alerting security but nabo baba balaba nti kirabika gwe twagala okubeera naye oba gwe twagala okusigaza naye alakaze yeetegese okitegedde muganda wange. Bino bintu byakwetegeka kujja kimafiya. The sunrise, the rising sun. Ndoza kuze muganda wange. Yes, subscribe, like and comment tubeere nga tukwasaganya ensonga eno. Subscribe, like and comment tubeere nga tukwasaganya ensonga eno and you can easily tell me nti nze ndi Kenya, ndi Mbalala, ndi Rwanda, ndi Congo, ndi South Africa, ndi Juba, ndi Qatar. Kenny Luchams the man ndoza naye mumulabe kati awo era ogenda gamba nti I'm exposing kubanga wano kamera yeebe ekulaga nti kino kyekitambula. So tell me, are you watching from Kenya, Juba, Abu Dhabi? Abali Abu Dhabi kitambula kita abangambye abaana be Abu Dhabi emirimu bwe gibula mudda mu kutunda kabiya naye baana mmwe. Kenny Luchams wuuyo kamubawe. Council Aaron Kizza yewe njogerera kati wali waneno. I'm watching here in Dubai. How are you Dubai? Wama abantu ba proving mbozi njogera nchamu all in all, thanks for updates. Thank you Mugana and Sunrise. Thank you very much for appreciating the work we are doing. It is the heavy media. Morning, hope all is well. Ibanda, my guy from Ibanda, how are you doing? Enoch, ensonga ndowoozo zirabwe zitambulira ddala bulungi. Omukulu Aaron Kizza ayingiddewo sebo eno kamera biyimbaza abantu bakimanyi nti oli musajja wamumanyi naye tuzanira omusajja ono akuba bifaananyi bya bukedde. Buli bajja wano agamba simulaga bantu uyo akuba bifaananyi bya bukedde
ati ng'oteeza otya bana kye bagamba
eno seti y'abannamawulire we babeera kale tutambula mpola ekintu ne tukikwasaganya. Oyo bamuyita Council Aaron Kizza aba ayingidde wenjogerera essaawa zino ono omusajja gwembalaze akola ku Bukedde akuba ebifaananyi oba oyagala amawulire mu mpapula za Bukedde byonna luyimbazi waali wano. Abamwagala nga mugamba nga mubawa tubagaliza buwanguzi bwokka. Muwonge Ronald, thank you. Where are you watching us from? Waliwo baganda bange abali Qatar, waliwo baganda bange abali mu Abu Dhabi awo Jeddah, waliwo baganda bange abali could you please use English? Okay, no worries. We shall try to speak English and some Luganda, because here most of us loud and clear. Thanks heavy Eddie, thank you very much Muganda wange. This is the Heavy Media Arod Kaija SG wekibina echa musajja atuuse naye osobola okubanga ensonga zonna ozigoberera bulungi nnyo. Yes, ensonga zonna osobola okubanga ozigoberera bulungi nnyo. Yes, right now we are waiting for Dr. Kizza Besigye. A few minutes from now, for those of you who want to speak English for you, right now we are just waiting for Dr. Kizza Besigye. That is Counsel Aaron Kizza, the lawyer. Nowadays I hear they call him the lawyers, the people's lawyer. Okay, that's what I hear from you guys. So if he's the people's lawyer, I want the people to be here to see what is going on, what is happening. Remember Dr. Kizza Besigye last time was brought here, and he was brought here for a PWE, a PW. The PW means the warrant of arrest. I mean, in the law system, we have what they say about we have what they call you are reporting about security, right? Problems so far they announce. All right. Kenneth, how are you doing? Hope everything is moving well and smooth. Dr. Kizza Besigye, for the first time, for the last time we came here for the PW, they call it PW, production of warrant. So somebody in Luzira is picking up, is just in case you in Luzira or you are in the prisons. The PW, anybody can pick you up from the prisons and you come to the court. So if you come to the court, it is all about the proceedings of the matter and go and just proceed with the matter. So last time they came around here and things weren't in touch. Business was not here. But if the business didn't go around, business didn't move. So business didn't move because Dr. Kizza Besigye didn't give what you can call instructions to to his lawyers and Lukwago, the lead counsel. He was like, Martha Karua was not here in the court. So the lead counsel, Martha Karua, was not in the court, and Lukwago, he was in his or her shoes. By the time we had to wait for Martha Karua, we couldn't, because Martha Karua had just gone back to Kenya. So today we are expecting Martha Karua to be here. The proceedings will go on just in case Martha Karua comes around. We expect a team of lawyers, because if, as you know, Dr. Kizza Besigye has a lot of lawyers. It is a number of lawyers. They are at most of 30 lawyers. So we shall be getting each and every update right here at the Heavy Media, just in case you don't know what is going to transpire for today. Dr. Kizza Besigye is coming through, and when as I speak right now, is in the docks of this court of Nakawa Magistrate Court, and they are coming around here a few minutes from now. We hope a few minutes from now we shall be starting this court. So keep on, subscribe, like, and comment, share this live, and we make it happen. It is the Heavy Media, and I'm yours truly, the Heavy Heart MC. Let's proceed. Yes, let's proceed. Tell me. Let's go back on our routine. Tell me, where are you watching us from, and we make it happen, ladies and gentlemen. You can tell me where are you watching us from, and we proceed with our we will proceed with our rotation, and we proceed how we do it on this channel. You remember, this channel is it is not a new channel, but we are trying hard, if you go to our bio, this is not a new channel. It is from 2012 up to now. We are in service, so we are big as that, we are heavy like as that. So let's make it happen. Subscribe, like, and comment. Tell me where are you watching us from. I wanted to show you Aaron Kizza, but Aaron Kizza is obstructed by Malema Birizi. But we shall go mpola mpola, tujabanga tutambula mpola mpola, ekintu beere nga tukikwasaganya mpola mpola baganda. Tell me where are you watching us from. Tell us where you're watching us from. Tuberenga tukubuulira buli proceeding yonna nga wegenda okubanga etambula. Tell us where you watching us from. You are live at the Heavy Media. It's Huntington. Huntington, how are you doing? Yes, Huntington Agamba is one of our strong PFF supporters. Huntington, thank you for watching. Banda, how is Banda doing? I want to be Banda. How are you doing, guys? Huntington, hope you're doing good. Subscribe, like, and Huntington, if you've not yet subscribed, please subscribe, like, and comment, share the live, and we make it happen. This is the Heavy Media. Kefa, live from Kibuka district. Kibuku district. How is Kibuku district? Hope everything is doing good. Hope everything is moving. Let's move. Dr. Kizza Besigye, a few minutes from now, is coming in court. A few minutes from now, Dr. Kizza Besigye is coming in court. So let's keep it on. Keep it burning. A few minutes from now, Dr. Kizza Besigye is coming in court. That is Aaron Kizza for you. He's just waiting, as you see. Aaron Kizza is there for you. Malema Birizi is there for you. Counsel of Captain Dennis Olla is also around here. Yes. Counsel for Captain Dennis Olla is also around here. So let's make it happen. Let's make it a date. Let's make it happen. Subscribe, like, and comment. You are watching the Heavy Media. Or your counsel, Mwangambi counsel is your the people's the people's counsel. So if the people's counsel is here, Justice live in Entebbe. How are you, Justice? Hope Entebbe is doing good. Hope Entebbe is doing fine. Everything is cooler. How is Entebbe? Akaimba kakinsanga kuweereza na chakarangane tata wache Entebbe. Abana b'Entebbe, big up on yourself. Counsel Aaron Kizza happening here. Ensonga zino kubanga naye azirindiridde, ensonga zino kubanga azikwasaganyiza ddala bulungi. Remember, last time the issue was about Martha Karua not being here, and I hope Martha Karua, the flight came around, and I hope Martha Karua slept here in our beautiful country, Uganda. Remember, saga zizaliwe Tanzania, tesima Martha Karua, we don't want to go there. It will be another day. Live from the West. Thanks for the work you are doing for us who are far away. Francis, thank you. He's in the West. Watching us live here at the Heavy Media. Abantu ndowooza feedback mujulira bwebebaliza ddala ensonga zino era bwe bannyonnyola okuba nti nno bebaza buli kimu. Wamanya Price, live from Rukunjiri. How is Rukunjiri, where Besigye is born? How is Rukunjiri? Rukunjiri people, you should be in court, most of you. I don't know why you are out of court. Rukunjiri people, you should be in court. Rukunjiri people, you should be in court, and you stand with your man, you stand with your God, because it is high time now. It is high time now you stand with your guy. Mbalaga Kansoyo Orensonganti is one of the lawyers of Dr. Kizza Besigye. Counsel Aaron Kizza ate y'omu ku baasibibwako n'abeerayo ebbanga. Yalozaako ku bukambwe bw'abasajja. Yalozaako ku bukambwe bw'abasajja. Live in Rwakabengo, Rukunjiri, we stand with Doctor. All we are waiting for is Doctor today. Doctor is coming. I know you are waiting for him. Silva watching from Mbarara. Thank you very much, Mbarara people. How are you doing? Hope everything is moving smooth and good. Counsel Aaron Kizza live. Ndowooza ensonga ozibulaba bulungi nnyo nga bwe zitambula, era ndowooza ensonga ozigoberera. Kale bakuwange watching from Forty Porto. How are you doing, my guys from Forty Porto? Members live in Kasese. Nicholas watching from Rukunjiri. Chakarangane tata wa Chentebe. Alright, subscribe, like, and comment, and we make it up. And subscribe, like, and comment, and we make it up. And it is the Heavy Media. Let's make it up. And Dr. Kizza Besigye a few minutes from now. One, chance. Yeah, they fail.
What is that?
Yakola. Yakola. That's how much you jump into a bus. Tujja kuggwaako solo eyiye nze olaba nze kati olaba muganda wange newobeerako n'akakadde nze nina abantu babiri bazze kukola nange byange anti kyengezaako okugamba kati olaba oluusi kiyinza n'olubi omuntu okugamba omusajja atututeko abantu kati nga kikolaba wano kikasuku nekijja wano tetusigaza muntu
olukazukugajja wano ye namala agamba nti natandisa ogenda mu fiiru naye aluuzizi agendanga musiko nga
kyembadde ngezaako okugamba nti kati olaba abantu nze natya nnyo nina abantu benalaba wano nemala tenzija nembalabawo ngaate bakomentinga alina abantu besebo abadde eno lwakuba mbadde siriiku lwakuba nebaddukira ebisingo kati kati nange waliwo mbana akateekako kati olaba namukola konti yakatanga olaba katanga oyo bayutuba bakona abamukola naye buli wenteekako wabawo abagamba direct the media we have been waiting for you so nga olabira ddala nga newobayo nabataano abali social omusango Dr. Hazeta. Wow, extreme. Naberanga mukola Besigye nasina sitani. Ngate ndi mubi nnyo ng'omukono tegufuuwa kati ono omwana yazanyidde ku sitandi yange naye agirina weemutenga Besigye oyo kabugo kasita omulaba kuba kuvuyisa legendary kabugo kalesewo naye onajawaawo abasajja nga bazereeti. Alaikum warahmatullah. Bebagenda oba obujulizi. All right. A few minutes from now, the preparations are so high. Right now, as I speak, the preparations are so high. Subscribe to the channel, like and comment. I will make it happen. The preparations are so high right now. In court right now. We are moving slowly, but the team of the legal team of Dr. Kizza Besigye, as I speak, it is already in the building, is already in the court. We are just waiting. For just a few minutes to get started. The judge is already here at the premises of court. The legal team is already here at the premises of the court. Mr. Mpanga is already here as I speak. Mr. Mpanga, the council Lord Mayor Elias Lukwago is already here. Martha Kalua is already here. They're just getting some. They are just getting some instructions from. These guys are just waiting for instructions from their lawyer, from their. Doctor, a few minutes. Just a few minutes, the court is getting started.
Beera mu.
Yes, Council Aaron Kizza naye ali mu kufuna ku bujulizi bwa kooti abusigaze ensonga zigere. Just getting some pictures here to update. Besigye and others. Killer, how are you doing? Yeah, see ya. Thank you for subscribing. For all of you who have subscribed, subscribe, like, and comment. Subscribe, like, and comment this live. Subscribe, like, and comment, share. Tukivenga tukikwasagana. Awo besinga okulaga awo besinga okulaga awo legal team. Mojina. As we speak, Dr. Kizza Besigye is right now here. Doctor has arrived here right now. We're talking about. As we speak, Doctor, he's arrived here at the court. So proceedings, anytime from now, we are moving. Anytime from now, we are moving. Anytime from now, we are moving. So just keep it on, keep it on, keep it on. Keep it on, keep it on, keep it on. Yes, Doctor, wetwogerera ayingidde. Abaloya batusedda babadde bakyayogerezaganyaamu naye. Mpanga abamwagala naye yatuuse dda. They have not just entered the court, but in a few minutes from now, they are getting inside the court. Waliwo abali mu kunkubira bannaye ndi mu kukola badde mbasaba tuwuliziganye maaso awo katono oluvannyuma lwa wano. Abantu bali mu kubeera nga bagoberera ebigenda mu maaso, so oba okuba oba okyankalanya live gen. Alright. Sorry for that. Musonyiwe mu katono nnyo. Mbadde njogerera ku bana abankubira bannaye. Stop calling me one. Tuli mu kukola bannaye. Njagala balaga Council Aaron. Labayo abantu. Let's make it happen. Council Aaron is there for you. Council Aaron is there for you. The people's lawyer. Council Aaron is there for you. Ne Council omulala owa Captain Dennis Olana yayingiddewo dda. Let's make it happen. Let's make numbers. Kasitola boyo omulaba ndowooza n'oyo naye Council wa Dr. Kizza Besigye omu ku bakansa abato. Innocent watching from Rukunjiri. Let's make it happen. Let's get the numbers. And we'll make it happen. Bw'olaba Council y'ogolaba awo. Ensonga nga bw'oziraba bwe zitambula essaawa zino kati ate kooti wenjogerera atannaba kujja tusaagala osubwe saagala osubwe kigenda mu maaso wenjogerera Dr. Kizza Besigye eddakiika 2 zokka ezibulayo abeere nga ajja mu kooti wenjogerera eddakiika 2 zokka. Abantu abo ndowooza nga oba balaba bwe bayingira babadde beebuuza Lord Mayor wetwogerera naye wuuyo ayingidde olwaleero akubye masuuti. Ennyimba nazo ziizo zitandise.
so kweyisayisa muganga okwebuuza
Members. Just a few minutes from now, Dr. Kizza Besigye is getting inside the court. A few minutes from now, Dr. Kizza Besigye is coming inside the court. Members. Ankuba n'engolo abantu bange bali
Sajja batatu babuna agamba wano kozesa kibuli. Ojja tukubya. Ojja tukubya.
bakubira
Tukubya.
bakubya nti
Ababadde baleeta emmotoka luga wano tulina kozesa kibuli.
no kyekino buli obalaba buli wemubaleka bwe muti bakontinu nga bakola ebyo ebyekisiru
singa batuula ebimu bantu
mabegawo
Ani akutaddeyo?
Mary,
ono
Ani
omusajja
ayonga? Deborah.
Kanso Abbe Kasekajjako naye ayingidde era mu nsonga zino mwaziri nnyo be bamukuba kansa abato abawolereza Dr. Kizza Besigye. One of the youngest counsels or the youngest lawyers of Dr. Kizza Besigye. Simanyi bani b'olabye behind naye. I don't know the guy also. I just meet the guy in court. Oli omuntu. Oyo guy bangambye wa PFF. Mumumanyi namwe. Guy wa PFF. Luyimbazi tulira ddala wali tulira ddala awo ewali loya wa olla Ruhindi. Hata Ruhindi town. You know that place? Hakuna Luyimbazi. Council Mike Chintu okuvira ddala wali eri mu bitundu bye katika mu South naye ayingidde. Era mutwogerera Council Mike Chintu gwe mulabaawo alu katika mu South ensonga agenda zikwasaganyiza ddala bulungi eza Parliament era mumulabiranga ddala. Yes. Where is Aaron? Ani omulala goyagala nkulage? Yagala footage. Wangambye wenyimirirawo tojjako. Yagala ebifaananyi abiyina. Talina kyeyegayirira. Naye nze mwana wattu n'ofukamira nfukamira era wengambira. Obaddeko eri Besigye byayingirira.
Binyumise, oddeyo binyumye ofiisi.
Abadde baagala Council Mpanga is all right there. For those of you who've been waiting for
alina nze ayimiridde mu
omusajja ng'eddaluwa muyigiriza lingi kajja kuggwayo nze nakugajja mu kuba engolo Council, good morning. Good morning, Council.
Fine.
All right, subscribe, like, and comment. Subscribe. Subscribe, like, and comment, and we make it happen. The court is full to capacity. Court here yajjudde dda, court yakubyeko dda, ensonga zonna zitambula ddala bulungi. You have a media dakiika mbale kati just 1 to 3 minutes. 1 to 3 minutes. People from abroad, where you welcome. Council, thank you for watching us. Thank you for the following and subscription. I'm seeing Imabilis is already here. He's been here from the morning up to now. He's already here. Council Thank you. Martha Karua is there, the lead counsel. Last time she wasn't here. subscribing akona mukadao ensonga tubenga tuzikwasaganya. We are just waiting. We are just waiting. Dr. Kizza Besigye ndowooza ekiri wabweru okiraba. Ekiri wabweru okiraba ndowooza ekiri wabweru kyekyo. Kitegeeza Dr. essaawa yonna okuva kati ayingira kooti. Dr. essaawa yonna okuva kati is getting inside the court. Most especially ennaku zino baadde bamanyi omuyise manju wali mola olujja olwo. Dr. bamanyi omuyisa awo ebiseera ebimu n'ayita wano awo olaba abasirikale abo. Yes, ensonga ne zibeera nga zitambula. Of course. Council, tell them to share the link. Yes, Council Cosman. Council Cosmas. Thank you very much for the messages like that. They make us very warm. Let them share the links. Let them subscribe. It is the only channel here to get Live from Iganga Tembo Street. Farouk Senyonga, how are you doing? Essaawa zino wabulayo eddakiika ntono nnyo. A few minutes from now we're getting Dr. Kizza Besigye inside the court, and when Dr. Kizza Besigye gets in court, business is going to proceed without any game to play, okay? Without any game to play. That is what is outside. 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 Ekyo kyekiri wabweru ekyo. Ebimu sijja byogera nnyo ekyo kyekiri wabweru. So kati manya Heavy Media, thanks for the live update. Silver. Ne boy, olingo yatupatanye. I think complaining katulinde mu party
nga nengero bane byo mwakwata eria anionde gundi lwimbazi mweyongere kema bwe batuuka era mugenda kukyanga byomwaka kane.
We are good, Victor. Hope you're good. Guys, let's share the link and we support the Heavy Media. Silva, thank you very much. Let's support the Heavy Media. Love those messages. Where is Besigye? As you see the uniforms. Ndi wano ne Siniabu, ndi wano ne Ajati Amina. Ayomba okufa oba mulabiseemu.
Ani golabisa.
Nze nkulabisaamu eddakiika.
Ndabisa tulaba nakuwa ebifaananyi
badde ngituusizza. Wano Ajati Amina naye antwalaganya. Okay, let's subscribe, like and comment. Like they've said, let's support the Heavy Media. Dr. Kastola Bo Yao. Tegeka camera your lead counsel. Everything else. Dr. Essaawa yonna. Essaawa yonna. Dr. Essaawa yonna ayingira. Lord Mayor avafuna instructions ezisembayo. Mpola Uncle Lord Mayor avafuna instructions ezisembayo. Lord Mayor avakufuna instructions ezisembayo.
That is expected.
The Lord Mayor is from picking up the last instructions from Dr. Kizza Besigye. They are bali mugezaako okulaba wano Ssemujjunga bamubuuza ku nsonga ndowooza nga bw'okiraba obawayamu wano nawali Dr. ngambye tukole bwe tuti kino tukikole bwe tuti kino kinaasoboka okutambula bwe kiti byebigenda mu maaso awo. They are getting some conversation kubanga balaba ekyokukola.
Shamim. God bless you.
Ekyambalo mukirabye naye bano abaana bategeke ekyambalo bakyambadde ekyambalo bakiyiyeeko ekyambalo bakiyiyeeko love one. The words are free Dr. Kizza Besigye oba Kebbi, obedi lutale now. Leero nno wano waliwo embaga. Abaana bambadde ebyambalo wano. Obutambala bulina entambula.
We shall never surrender. We shall never surrender. Never surrender. We shall never surrender. Never surrender. Never surrender.
Zoom. Are you recording?
I'm yours.
Case number 8 should confirm that Uganda versus Kano. Besigye Hajji, and Captain Olla.
Please, Your Worship. Richard Kumbuka, Chief Secretary for Prosecution. All accused persons are in court. To accuse senior counsel Matthew of introducing the defense.
Together with Elias Kwabo, FK Mpaka, Katumba Apollo, Proscopia Unihira, Secacho Abubakar, Secacho. I'm pronouncing the Kenyan accent. Aaron Farouk Kamleger, Bayan Filinara, Kintu Michael, Wadara Isaac, Katuswa Tobias. That is for the first and second accused. And for the third, Mr. Simon Subuga.
Please, Your Worship. This matter is coming up today for further mention. However, we wish to make an amendment on the charge sheet.
Please, Your Worship. We are opposed to any step being taken by the state before we make our application, which is outstanding since the last time we appeared here. And it's a command of the Constitution, it's a command of the MCA about the next step in the end of the proceedings before you, after the expiration of the sixth, the mandatory remand. So we wanted to proceed with our application, Your Worship, before any other step is taken. Most of that, Your Worship. Your Worship, we pray that you will be pleased to release A1 and A2 on bail in accordance with the provisions of Article 33 of the Constitution. My Lord, Your Worship,
Clause 6 of where a person is arrested in respect of a criminal case, and in the case of an offense triable only by the High Court, if that person has been remanded in custody 180 days before the case is committed to the High Court, that person shall be released on bail in such conditions as the court considers reasonable. Comparative word here, Your Worship, is shall be released on bail. That what gives this honorable court authority and mandate to invoke these powers to release the accused persons on bail. So, Your Worship, from the record, the accused persons have been on remand since the 20th day of November 2024, well beyond the mandatory period provided for under Article 23, Clause 6, Paragraph C. This particular provision is reinforced by Section 76 of the Magistrates Courts Act, which reads as follows, if it may please you, Your Worship. If an accused person has been remanded in custody before his or her trial commences, in respect of any offense punishable by death, for a continuous period exceeding 180 days. B, in respect of any other offense, for a continuous period exceeding 60 days. The magistrate, before whom the accused person first appears after the expiration of the relevant period, shall be released. The magistrate, before whom the person first appears after the expiration of the relevant period, shall release him or her on bail on his or her own recognizance, notwithstanding that he or she is accused of an offense referred to in Section 75, unless one, he or she has, prior to the expiration of that period, been committed to the High Court for trial. Excuse me. Now, Your Worship, from the record, the accused persons have spent over 180 days. That's a fact which is not controverted. And it's also well canvassed in the affidavit of Queen Hira Proscovia, which we filed on record, to bring out the history of this matter and the chronology of the events, right from the time the accused persons were kidnapped from Nairobi on 16th of November and taken through the processes before the General Court Martial on the 20th day of the same month, November 2024, and remanded to Zira, where they have been languishing up to the present moment. All those particulars, those facts are borne out in that affidavit, are brought out rather in that affidavit, which is not rebutted in any way or controverted. Your Worship, on record, on the 31st day of January, the Supreme Court directed the General Court Martial to cease any trial of civilian cases, and that all those matters be transferred to the ordinary court, to the conventional courts, the courts of judicature. And that is the genesis of this matter. And that's the reason we are here. So that has been the chain of the events right from the time of kidnap to formal charging or indictment, and then subsequently remand, and up to the present moment where we are. So now, Your Worship, here, there are two things we need to emphasize here. After clocking 180 days on remand, two things here are fundamental. Number one, this magistrate court cannot take any other step except for handling the proceedings relating to the release of their children. No any other step. This honorable court cannot in any way proceed with issues to do with the amendment of the charge sheet or any other action be taken except to issue an order of release. On such conditions, court may deem appropriate. That is number one. The second one is have they been committed before the expiration of the 180 days? The answer is no. And this is the spirit and the letter of section 76, paragraph B1. Unless he or she has, prior to the expiration of that period, been committed to the High Court for trial. Prior to the committal. So there has not been any committal before the expiration of 180 days. Even if there is any committal proceedings to be taken in the future, it doesn't host the jurisdiction of this honorable court from going ahead with the mandatory pay. Second, the proceedings that may be considered later would not operate as a bar for court to proceed with this command of the law. Would like to ask this honorable court, Your Worship, to look at the spirit of this particular provision, why it was enshrined in this, why it was put into the Constitution, and it was couched this way in section 76. Why this particular provision was couched to stamp out persecution, impunity. It was intended to stamp out impunity and persecution. When you look at the provisions of Article 43, the framers of the Constitution were alive to that fact that the state may exceed what is actually within the remit of what they have powers to deal with, and descend into the realm of persecution. And that's where we are now. That's the limit, the reason there was that limit of 180 days, and the court was given those powers that please, once the state has failed to take steps to commit their chosen persons within 180 days, first appearance before you as a magistrate, don't do any other thing. Please just consider releasing their chosen persons. And that's what we are asking for, Your Worship. This honorable court shouldn't acquiesce or be an accomplice in the persecution of their chosen person by the state. So the only thing that should be done at this stage is to release their chosen persons on such conditions you'll deem proper. We do so, Your Worship.
Worship, if I may add, just for emphasis. Worship, again, Article 23(5)(c), the command of the Constitution, says shall, therefore does away with the ordinary bail application, which is made that allows for a it is a constitutional command. What the court ought to satisfy itself is that the offense is tried only by the High Court. And that the person who is the applicant has been on remand for more than 180 days for committing. So I join issue with my senior colleague, Mr. Kwaku, that the committee per se does not take back time to nullify the 180 days. The 180 days are a constant. Two, the worship, is that the 180 days referred to in the constitutional command do not start to run from the date when the applicant is arraigned in the court before which the application is made. Yeah, I'm saying that the 180 days, upon which bail becomes mandatory, are not counted from the date when the applicant or the accused person was arraigned before court, before which the application. And mindful of the decision of the Supreme Court, the Supreme Court directed a transfer of the files. What I'm trying to say, Your Worship, is that the process from the court martial to this court is continuous. There is no break so that the proceedings before the Court of Appeal, the court martial, are not taken into consideration. So when we speak to the 180 days, Your Worship, the court must take into consideration the date of remand by the General Court Martial, because it is also a court under the Constitution. So that article, Your Worship, again for emphasis, says in case a person has been remanded in custody, doesn't say, it envisages that a remand can be made by any court of law, or any court as established by law, of which the General Court Martial is just one of them. So the argument that may arise from the prosecution that the proceedings in or before this court did not commence or commence this year, and therefore they are not 180 days, does not hold. Court takes into consideration the time when the remand started to run, count the 180 days. And Your Worship, there is a view that perhaps in matters or offenses tried only by the High Court, the magistrate's court should not grant bail because the matter is tried by the High Court. Your Worship, in the current constitutional dispensation, the magistrate's court is empowered to grant mandatory bail. Your Worship, it's a common fact that the Constitution applicable in Uganda was promulgated in 1995, so that decisions made thereafter bear in mind the constitutional order of the day. Your Worship, in Uganda versus Tesimana Rosemary, the Honorable Mr. Justice FMS Egonantende, as he then was, Tesimana Rosemary, is Criminal Revision Code number MSK hyphen 00 hyphen CR hyphen CV hyphen 0013 of 1999. I cite it because it is the current dispensation. Because in that case again, Your Worship, the magistrate had declined to exercise powers and sent the file up for revision on the ground that the matter was tried by the High Court. Your Worship, I beg to read and I'll avail a copy. My Lord, this is Your Worship, it's the highlight at page 13. But before I take leave of this case, I must say that courts cannot escape blame for this unhappy set of affairs in the criminal justice system, which has no remorse for caging up people in penalty. In Article 23C, therefore, the accused persons contend that they have been on remand by order of the court so established under the Constitution, the DCM, for a period exceeding 180 days. If I count well, Your Worship, then they should be 196 thereabout. And that the matter which is before this court now is because the accused persons are exercising their right to mandatory bail as commanded by the Constitution. The onus of the court is upon being satisfied that the 180 days on remand have elapsed, is, as the provision says, that person shall be released on bail on such conditions that the court considers. Your Worship, we are mindful of the fact, and were told before, that there are practice directions regarding bail applications, or bail for that matter, in magistrates' courts, which were handed down by the principal judge in regard to capital offenses. Your Worship, those practice directions are not in respect to mandatory bail. They are in respect, what I would say, for want of another description, ordinary bail, or bail in ordinary circumstances. In this case, the reason why the Constitution makes a specific command is that the state is expected to have wound up its investigations and made a committal in 180 days. In the event, Your Worship, the practice directions of the principal judge and even Chief Justice cannot override the express provisions of the Constitution. Just wish to remind the court, and we are aware that the court is already aware, of Uganda and shall have binding force on all authorities and persons of Uganda. So, Your Worship, that means that the Constitution and its provisions have binding force on this court, on the persons of the Chief Justice and the Principal Judge, ordinarily in their individual capacity, and also in their official capacity, exercising their powers as the Chief Justice and the Principal Judge, respectively. So much so that the practice directions they pass must be brought in conformity with the Constitution. They cannot surpass or override the power in Article 23, which my land colleague, Mr. Rukwago, Senior Counsel, reiterate the prayer. 180 days have elapsed. Now the defense, we shall happily receive the conditions for the mandatory bail according to the command.
Yeah. Worship. One of my colleagues will submit an authority. After me, then senior counsel will close our presentation in this application. But I want to start with just emphasize the practical matters. The date of remand and custody was 20th November 2024. Vice General Court Martial, criminal case number UPDF stroke GCM stroke 040 stroke 2024. The state is aware of this fact because they have said so. In an affidavit before this honorable court, the state, through its detective IP or Diek Benedict, they acknowledge that the respondents, namely the accused, were previously charged before the General Marshal at Machinde. The application was filed on 5th March 2025, and it is the application for accessing the court records.
No, the telephone.
Yes, the telephone particulars, which Your Honor is on this honorable court's record.
I think George is just
I will not say the word and you're panicking. Yes, you can't stop me before I say the thing. Relax.
So what I'm saying is that the document which and therefore it cannot form. We cannot preempt a document in an application which has not been had and use it as in your
Your Honor, before I was rudely interrupted by the representative of the government of Uganda, I was going to draw your attention to, among others, in this very court, criminal miscellaneous application number 001/2025, in which the number 01 of 2025, in which the state made reliance to the affidavit of Detective IP Odiek Benedict, who saw that he's aware not only the accused were charged before the General Court Martial, but that he's also one of the people who are charged with investigating their matters. That is the date of custody or remand in accordance with the Constitution. Your Honor, the brief for mandatory bail that my comrades have emphasized pursuant to Article 23, Clause 6, Paragraph C, is intended, among others, to ensure that the accused get a fair hearing. The only way people can effectively defend themselves who have spent 6 months on remand is when they have liberty to defend themselves from home, and also to ensure that their trial is and detention is not too lengthy. Your duty as this honorable court is partly adumbrated by Article 20 of the Constitution. Clause 1 of Article 20 of the Constitution reminds us that the right to liberty is inherent. It's not a gift of the state. Clause 2 of that article is the effect that this court, the office of the Director of Public Prosecution, and other people should not only respect and uphold the right to liberty and other fundamental rights, but also promote them. What we do here this morning should be seen to promote the liberty of Besigye, Obedi, and Dennis. It should not be seen as frustrate their liberty. And should the state get wayward and try to frustrate that liberty, it behoves you as the judicial officer presiding over this matter under that article to rein in the state and ensure that it's back on the track, the constitutional track of guaranteeing that liberty. These provisions of the Constitution are very important because the Constitution is supreme. The supremacy of the Constitution is underscored by Article 2, clauses 1, 2, and 3 of the Constitution. So any other speech, any other law that tends to negate the constitutional entitlement to liberty after 6 months
court takes the view that the authority that was submitted is of an earlier date. Your Worship, formally in 2022, the Honorable Justice Jesse, sitting at Masindi, the High Court, in Nyangoma Flavia versus Uganda. Nyangoma Flavia versus Uganda. In criminal application number 7 of 2022, and page 3, paragraph 4, had the opportunity to say this, and I will quote in verbatim. I have perused the lower court file copies of the lower copies of the remand warrants and the applicants and 7 others. The remand warrants are to the effect that the accused persons were remanded first in prison on 12 November 2021, save for Kato Francis, A8, who was released on bail on account of being a juvenile. Since 12 November 2021, when the applicant and the 7 others were first remanded to prison, more than 180 days passed before the committal to the High Court. It follows, therefore, that neither the magistrate's court nor the court that has neither the magistrate's court nor this court has any discretion not to grant them bail. It was a violation of Article 23, Clause 6, Sub-Clause C of the Constitution for the magistrate before whom the accused persons first appeared after the expiration of the 180 days remand period to decline or refuse to release the accused persons on bail, for he or she had no discretion to do so. Your Worship, if I may add, is that such a decision of the High Court has a binding authority nature on this specific court. Your Worship, the Honorable Justice Jesse Yarohanga took a view that the magistrate does not have discretion to deny an accused person who has appeared before him or her after the lapse of 180 days. For avoidance of doubt, Your Worship, the accused persons were charged with murder, which is a capital offense and only tried by the High Court. Your Worship, my comfort in that authority is to the extent that this decision is of similar nature as the case we are faced with today. And therefore, I reiterate the area of prayers of my learned brothers that the accused persons are entitled to be released, and keyword entitled to be released on mandatory bail by this court. And this court has no discretion in application. Much of that, Your Worship.
Before I answer my 2 points, I just want to tell my learned friend, the prosecutor, that it is unfortunate that he would refer to the previous incarceration of Aaron, whether in jest, knowing very well that it was before a lay court, because he saying that he may once again be elected. It's not a fair thing to do.
Someone has has collapsed. Just has collapsed. Yes. Sorry, bro. Just the soko for now. Kuba omulanga. Kali mulungi bana. Teyeweka.
Tambule.
I'm not recording.
Can we have what I report as question? I was just expressing the fact that my learned friend would joke with liberty of our colleagues taken away illegally as the Supreme Court found. But having said that, I want to commend my team. They have demonstrated to honor the law on bail and the fact that the court has no discretion whatsoever. But we also want to refer you to one more case from the Supreme Court in the Foundation for Human Rights Initiative versus the Attorney General. The Solicitor General, Constitutional Appeal number 3 of 2009. Just Katurebe, Foundation for Human Rights Initiative versus the AG. And as Constitutional Appeal number 3 of 2009. The decision is by Katurebe CJ, as he then was. He held that when an accused person applies for bail, the court retains the discretion whether or not to grant bail to the accused person, which discretion has to be exercised judicially. But now comes the most important. The only time when the court has no discretion is when a person has been on remand for the period stipulated in Article 23(6)(b) or 23(6)(c). In those situations, the court shall grant bail. I suppose the court retains the power to determine the terms of the bail. In other words, this is a Supreme Court decision, and this honorable court is obliged to follow not just the High Court, but the apex court decision. Now my 2 points. I want to refer you to the obvious, Article 136 of the Constitution of Uganda, which clearly states that judicial power is derived from the people and shall be exercised by the courts established under this Constitution in the name of the people and in conformity with law and with values, norms, and aspirations of the people. In other words, the framers of the Constitution and the people of Uganda put the trust in judiciary to advocate on these matters. I am therefore urging Your Honor, in exercising your judicial power and in giving the ruling in this bail application, to abide by the values of constitutionalism and the rule of law, And in the name of the people of Uganda, grant our clients bail. My learned friend will be submitting of the card on every, but they have a similar history of detention, not exact the same period, but anybody who has finished more than 180 days, you are obliged to release them pending their committal. I'm also reminding the court the obvious that the scales of justice must balance. And in Article 21, equality and freedom from discrimination, we come before you as parties with equality of arms. Therefore, the prosecution and the defense are equal before you. None is superior. And none should come with the assumption that they carry more weight. Therefore, it is your duty to demonstrate, because justice must not only be done, but must be seen to be done. That the scales of justice are balancing, and that you are availing all the parties, and in this case, everyone to every, the due protection of law. And the law on bail is for their protection. So we urge you to exercise your discretion to give them bail on such terms as you find fit to enable these proceedings to continue when they are free, because they have served the state in custody for the maximum period allowed by law. I yield to my colleague who spoke up for the AD.
Worship. First, I raise issue with the submissions of the Council Justice Kwabo, Panga, Kandua, Kizza, Brian. Contend that Captain Ola Dennis has been on remand exceeding the mandatory 180 days. Your Worship, Section 76 communicates to you and says that what happens when they present Ola to you after the elapse of the 180 days. You only left with one option: to release Captain Ola. These are the situations where you cannot release Ola. If he has been committed to the High Court, Your Worship, Ola has not yet been committed. Or if it is in the public interest that Ola must not be released, Your Worship, there isn't any evidence that Ola is harmful to the public. Your Worship, then back to Article 126. Exercise of judicial power, which is direct of the people. Clause 2. In adjudicating cases of both civil and criminal nature, Your Worship, these cases of criminal nature, the courts shall subject the law applying the following principles: that justice shall be done to all irrespective of their social or economic status. My Lord, that Your Worship, Ola is a soldier. We pray that he also enjoys the liberty that is granted, couched in mandatory terms under Section 23(6)(c) of the Constitution. It also further says that justice shall not be delayed. The framers of this Constitution were privy to the fact that criminal prosecution is delayed. That's why they came out with a position that when an accused person is remanded exceeding 180 days, the choice is limited. And Your Worship, I'm appealing and praying for the choice. Let me push me to the conditions that may be reasonable to grant olla bail. Olla is family man. The father actually he has children who have to go back to school. He's not sure that they'll go back to school because their father is here. That is olla. Any other application to keep olla in lawful custody, we submit that it is very absurd. In fact, Your Worship, doing issue with the other submissions of the senior counsel. So,
which was filed by the applicants. I don't know where the consciousness went because we have been serving each other. Prosecution has been making it a point to serve and fence each and everything that has been filed. That said, it is imperative, Your Worship, that you write us on our stand-up. We look through that affidavit and we make an informed response because we do not know what it contains. We want to look through it because it seems to have a lot. And it will be just fair and just the prosecution or the respondent looks at it. Also, we haven't been my colleagues have been submitting and they have been keeping authorities to themselves. There are people who are actually seeming fairness, but they are acting not as well. Every authority that has been talked about has not been given to prosecution. We feel that is very unfair in that regard because we believe they prepared for this application. The fact that they put in an affidavit in support, they were prepared and therefore they were supposed to prepare all the authority and also grant us an opportunity to prepare our defense in this matter. There's an affidavit of proscopia. We haven't. And this is what we are asking for, that what gives us 1 hour, only 1 hour, because we operate as it is, the way they do. So we need an hour to look at that affidavit and prepare our response. So we're going to give it today, after an hour. That is our right.
We are opposed to an adjournment for 1 hour. If he was talking of 10 minutes, 15 minutes, it would be okay. Because the only reference to that affidavit is to the date. A1 and A2 have been in custody from the 20th of November 2024. The contents of the affidavit were not part of this application. Because it's an application for bail. So if he wants to look at that paragraph, and I'm saying this because the court is aware that as senior counsel, I am coming from a neighboring country. I flew in today. I hope to go back later. We were in court last time. The prosecution opposed to us coming before the court the next morning. And then after I have left, brought behind us charges. If it's about fairness, let's treat each other fairly. The only thing mattering here is the date. Your Honor may give him 15 minutes to look at the affidavit. 1 hour is too
Your Worship, before my colleague responds, the last time we were here, we called Adjournment so that we make this happen. The person who was present representing the state was Mr. Richard Bill. So he's aware, because the court indicated we have just for your brother magistrate, because the presiding magistrate were not available. And it was made very clear that the application for mandatory bail will be made because the accused persons have stayed one. So that was the 21st. We told counsel. The other one about the authorities. All the authorities which are being cited are versus Uganda. Whereby Mr. Billy Vumbuka, representing Uganda, is a party. So it means that by default, the office which sent him argues the cases that they are not responsible to take stock of these authorities and armed counsel aware of what they're coming to do cannot be taken on to the True. He was aware he was coming to argue just that. And that is why court will note that when my non-colleague Mr. Atako asked that he tried to proceed with application, he did not because he was on notice. So his belated response perhaps is also courteous of counsel to agree when he's overwhelmed and concede that the circumstances are beyond him, so that court proceeds and pronounce itself on the conditions. So we do not accept the 1 hour because my colleague was aware of that.
Just like the Bible, when it passes and scriptures, the Bible of justice is the Constitution, which Richard Billy has had for time was not. And I do not think that an adjournment will have amendments to the articles of the Constitution. Although the article is speaking in command that these people, every ought to be released. Unless Richard Billy is going to come and address court and inform that he's proceeding, that Richard Dennis Ola goes home. If that is the position, I don't know about it. But if that's not the position, I oppose the adjournment from out.
Mr. Richard stated that when he stated that only the authorities that have been cited, he has been. He has an authority which I cited, it's even highlighted for him. So he's right that all the authorities that have been stated have not been given to him, and I pray that he withdraws them.
I'll take the notice that you have just submitted. So unfair. They can say, I don't have the authority. For sure, you are not submitting. But nonetheless, maybe God can take a decision on that and make us know.
So since the prosecution says that it needs to look at the affidavit, I'm going to give it strictly 10 minutes. The court is stood over for 10 minutes.
Court is taking a standover of 10 minutes. Court has took a standover of 10 minutes. They are coming back after 10 minutes. So just be ready and hear from the we want to hear from the magistrate judge whether Dr. Kizza Besigye is going to be given a bail, whether or not. But for now, the defense counsel, or the defense lawyers, they are of view of giving Dr. Kizza Besigye a mandatory bail today. For now, let's just wait what is going to transpire. We are praying for justice. Definitely, people here are praying for justice, and they will tell us. We shall get to know what's going to transpire after the next 10 minutes from now, and 10 minutes are so less, okay? So we are waiting 10 minutes from now to get to know what is going to transpire. Bawumuddemu eddakiika 10 zokka, kitegeeza nti eddakiika 10 wezigwerako twagala kumanya Dr. Kizza Besigye oba agenda kubanga aweebwa bail oba nedda. Wano wennyini tuli live. Nakawa, subscribe, like and comment. Subscribe. Tell me in these 10 minutes of a break, where are you watching us from? In these 10 minutes of a break, where are you watching us from? Just say Anchikutte. I camera yangu. Ayagala mukwata. All right. Dakiika ntono nnyo. Zigenda beera dakiika ntono nnyo 10 zokka. Kitegeeza mu dakiika 10 tulindiridde ekintu kimu kyokka, okubanga ate tulaba kanzige dakiika emu yokka. Kampitowo kati. Noli aguddemu abamugambye okugwa. Debula wuuyo awo akubye enduulu akyakaaba. Kampitowo maka. Okitambuza kampitowo.
Effective from the first remand.
That's a few minutes. Anso nsonyiwa basumbuwa eddakiika emu yokka, tukyali live naye njagala osooka otubuuliremuko break ya dakiika 10. What should we expect?
Already dakiika nyaziseewo kati kano katukakolera eddakiika emu.
Okay.
Kakati ekisooka nga bannamateeka ba Dr. Kizza Besigye, Dr. Obedi Lutale, tukyewuunyiza nnyo nti omuwabi wa gavumenti Mr. Richard Vunduka abadde akimanyi nti olwaleero tujja kusaba kweyimirira kwa Dr. Besigye, kubanga ye nga looya kino tumutwala nti akimanyi. This is a matter of law. Amateeka gannyonnyola buli situation kiki ekibeerawo. So olwaleero tubadde tusuubira nti mwami Richard Vunduka omuwabi wa gavumenti akimanyi nti etteeka lirikiriya mu article 23(6)C of the Constitution ne section 76 ya MCA nti olwaleero Dr. Kizza Besigye bw'ajja mu kooti ekiteekwa okukolebwa kuwuliriza bail application ye, so see any other thing. That's the command of the law. Kati ye byatuzzaamu ate amending charges ng'amateeka gannyonnyola kiki ekirina okukolebwa mu mbeera eyo olwaleero aba ali mu kumenya ssemateeka aba ali mu kumenya mateeka. So n'olwekyo asabye kooti eddakiika essaawa nnamba mbu asomeko mu affidavit gye twateeka mu kooti mbu tetwagimuwa. Ate ng'ekiri mu kooti si kya affidavit olwaleero, si kirayiro ekyo kye twateeka mu kooti, nedda ekiri mu kooti olwaleero Besigye amaze ebbanga ebisukka mu nnaku 180 ng'ali ku remand mu kkomera. Ate ng'etteeka linnyonnyola kiki ekikolebwa embeera eyo bw'ebeerawo. So ono kyaleeta ekya affidavit kyasaba essaawa nnamba era kiba kikyamu. Y'ensonga lwaki n'omulamuzi essaawa nnamba agigaanye okugimuwa n'amuwa eddakiika 10 zino ze tufulumye.
So briefly in English, Counsel Mike Chintu.
Yeah, today, as lawyers for Dr. Kizza Besigye and Hajji obedi lutale, we have been surprised by what the state attorney is saying, that he needs an adjournment of a full hour, because we have hinted on an affidavit that we filed in court regarding our bail application. Yet he knew, and he is presumed to know, as a state attorney, a senior state attorney, in fact a chief state attorney, he is presumed to know the law, that Dr. Besigye has been in prison for over 180 days. And the Constitution under Article 123, 6C of the Constitution, in mandatory terms, it directs that a magistrate court where such a person appears must release him on bail. The word used in the Constitution is shall, implying that even court has no discretion regarding that. It must release the person, save court has some few discretion there, that it might give some conditions to the accused person, but it must release the accused person. It's a constitutional command. However, the prosecutor has asked for an hour, which the judicial officer, the magistrate, has refused to grant, and she has told him 10 minutes, peruse the affidavit, and we proceed. You know why? This bail application is purely based on matters of law, both in the Constitution of the Republic of Uganda and the Magistrate Courts Act, Cap 18. So there is no way why the state attorney should begin asking for affidavits which are on court record. It is immaterial. He should confine himself to the sections of the law and the article in the Constitution. He doesn't need to delve into the Constitution. We have given court mandatory provisions of the law. So let him rebut that. Anyway, no wonder the trial magistrate has given him only 10 minutes to go through the affidavit as he wants for the sake of fairness, and then he comes back to court and we proceed. So we are waiting for him to go through the affidavit, then we go back to court.
Katikamu South, we are coming. Just a simple message for Katikamu South. Let's first finish.
Yeah, let me just remind my people who love me so much, people who requested me to come and stand and contest as a member of parliament for Katikamu South, people who want me to represent them in the Parliament of the Republic of Uganda, that I am coming. Chintu Michael, I am coming as a member of parliament. I'm coming to stand as a human rights lawyer. You can tell that even right now I'm fighting for someone's rights.
That one even in Luganda Council.
Yeah, so njagala kujukiza abantu bangawe Katikamu South tisinaba kuberabira nzija olwokutaano naliyo ne ku lwokusatu nabaddeyo era nga tuli mu kwogera ku bintu byaffe ebyenjawulo ebikulakulanya Katikamu South constituency abalema abeewo obulenzi n'aba meetinze. So nange okusaba kwammwe nakuteeka mu nkola era nenzikiriza okujja nkiikirire Katikamu South mu parliament ng'omubaka ddako 226 231. Tuli wano olwaleero nga bwe mumanyi omwana wammwe wa Katikamu South ow'Endejje ndi mulwanirizi wa ddembe. Eddembe ndirwanira buli wenda banyigirizibwa eddembe. Chintu Michael nja kubeerawo gwe munakatikamu South olonze Golodi londa Chintu Michael kukiikire mu parliament eddembe lyo obeere ng'olikuumye. Mwebale nnyo, mwebale.
Sakategede naye
nze maliriza nze yange biwedde.
Yeah, you see, based on my observation, good demeanor in court, given her expressions and demeanor, I think she's so much inclined to comply with the requirements and dictates of the law, especially Article 23(6)(c) and Section 76 of the MCA, by simply granting bail and giving conditions. However, I want to remind all Ugandans and the entire citizenry that in this country we have laws. some of them signed by the president and ratified. However, his word is above the law. So we do not know what type of communication the Prime Magistrate is going to get in this break. We cannot predict. We cannot speculate. So she may, because of the power of the state, not grant this bail. That is my suspicion and what I think.
Okay.
Yes.
Okay, briefly in Uganda.
Yeah, nze ndowooza nti akaseera kano ke tufunyako eddakiika 10 nga tufulumye ebweru. Omulamuzi bambi nze nga bwe mutunuulidde mu kkooti ndabye nga omwoyo gwe n'omutima gwe bikkiriziganyizza n'okuwoza kwaffe ne bail application yaffe kubanga esinziira mu mateeka ssemateeka ne Magistrate Courts Act section 76 MCA ne article 23 akatundutundu 6 n'akatundutundu C. So ndabye nga akkiriziganyiza naffe ate naddala bw'alabye ng'omuwaabi wa gavumenti atagala. So naye okutya kwange wekuli nti bannayuganda mwena mukimanyi nti wano mu Uganda amateeka bwe gali President Museveni yagasentingako tugalina naye tagateeka mu nkola ate instead agalwanyisa. So mu break eno gye tulimu siyinza kumanya omulamuzi bayinza omuyisaamu akasimu bayinza okumutiisatiisa nga emuze mu biraba n'asalawo ekyo ekitali mu mateeka n'agaana okuta Dr. Besigye ne Hajji Obedi ekintu ekijja okuba ekimenye ennyingo egyo enjogeddeko ya ssemateeka n'akawaayiro kali mu tteeka erifuga ba magistrate. So nze ng'omu mbuusabuusa nti anaakomplayinga n'amateeka olw'okuba nti Mwami Museveni bw'atyo bw'akola ebintu tagoberera
amateeka.
Counsel, thank you very much. Tugenda kwatagana edda.
Where do they sell? Where do they sell?
Excuse me. Kati nze ntandikira awo obadde ogamba otya? Nammwe muze mu kkooti mutudde muvudde ku mirimu gyammwe mufuuse ba alo. Wansitula ddi n'owulira nti kiro zaabwereere. Ladies and gentlemen, we are waiting for Dr. Kizza Besigye. Dr. Kizza Besigye, subscribing and soke mumbulire wawe musinzidde okuwanga mutulaba. First tell me, where are you watching us from? The 10 minutes are elapsing. Oyo gwe mbadde mulaba muyita Honorable Mike Kintu abadde attanya nsonga wano wazi abadde alina kutanya nsonga ng'aziyisa. So n'olw'ensonga eyo, tell me where are you watching us from? Tubeere nga tukwasaganya abaana ba Chisenyi, Kampala, how are you doing? People from Chisenyi, Kampala. Hope everything is doing good. Suubire nti ebintu bitambira ddala bulungi nnyo. Abali Kampala wano nga we mutulabira ekintu kye mukola kya kabi nnyo. A few minutes from now we are getting back. A few minutes from now we are setting back. Few minutes from now we are sitting back in court. Yes, tell us where you're watching us from. Sawa kuva kati Dr. Kizza Besigye is getting back in court. As I talk, doctor is there. Dr. Kizza Besigye akomyewo mu kooti eddakiika 10 ziweddeyo. Baba kati basaliddeko ddala tukwata mitwe kati tukwata mitwe gyammwe. Dr. Kizza Besigye back in court akomyewo era n'empingu zikyaliko. Abyenterezaamu katono.
Kagala gwe. Allô? 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 Mabilize. Senga. Obirana. Tokameza?
Since we never filed an affirmative reply, I pray for speed of court to this line. Your Worship, the applicants made an application under Article 33, 6C. Although my senior colleague was required to say Article 25. Your read was saying Article 25, but it's Article 26. 6C. Their argument is that the applicants
The magistrate is not allowed to be shown.
6 months. And they are premising their argument on the charges under the General Court Martial. Where the first two applicants, that is retired Colonel Dr. Kizza and Hajji obedi lutale, appeared on the 20th of November 2024. The defense or the applicants are also relating the same the charges that the applicants are facing before this honorable court. Article 23(6)(c), which is the basis of this application, is to the effect that where a person is arrested in respect of a criminal offense, and in the case of an offense triable only by the High Court, if that person has been remanded in custody for 180 days before the case is committed to the High Court, that person shall be released on bail on such terms as the court considers reasonable. This article is perfect. However, it doesn't apply in the instant case.
The applicants appeared before the General Court Martial. On charges which are triable, not only by the High Court, but the lower court. That one collapses the application because the article is very clear. Only, let me repeat it. If that person has been remanded in custody, in the case of an offense tried only by the High Court, the charges the applicants were facing before the General Court Martial were not offenses or charges that fall under C of the proceeding. In other words, it is only the charges which the applicants are facing before this honorable court that apply under Article 23(6)(c). This is a total misinterpretation of the Constitution by the defense. The applicants appeared in this court, which I may refer to as the civil justice system, on the 21st of February 2025. And this legitimate charge, which this honorable court has jurisdiction over, on the 21st of February 2025. That said, even if the applicants were facing charges that are referred to under Article 23(6)(c) of the Constitution, the charges of the General Court Martial do not apply in this honorable court, because the court martial is under military justice system. And this court does not have powers on any matter that is before the General Court Martial. The same applies to DPP, the Director of Public Prosecution, whom I represent today. So it would be irregular to bundle the two justice systems and hold the civil justice system liable for, actually responsible for what happened in or before the military justice system. As if that's not enough, the charges under the General Court Martial ceased and were terminated by the constitutional ruling of the Supreme Court. In other words, DPP never inherited any charges which were instituted before the General Court Martial. DPP initiated or directed for fresh and new investigations, which are the basis of the charges that the applicants are facing. The applicants furnished this court with a copy of the charge sheet, which was before the General Court Martial, and I believe this court takes judicial notice of the charges on the charge sheet apparently before court. And if that is the case, court may realize that the charges do not speak to each other. The General Court Martial has different charges, there are different charges, and here the applicants are facing charges which are completely different. But even if the applicants were charged with offences which attract death, even if the applicants were charged with offences which attract death before the General Court Martial, the civil justice system where this honorable court falls does not have jurisdiction and does not enforce the UPDF Act under which the applicants were charged. So that makes the two completely different. Your Worship, the question is, does this court have record of the General Court Martial? And if it is true that it does not have the way I believe, then this court, where does this court get the moral and legal authority to be bound by proceedings which are not before it? We invite this court agree with the prosecution that this court does not have any moral or legal authority to consider the record of proceeding in the General Court, even if it had it, because this court was not party to that. This court did not in any way inherit the proceedings of the General Court Martial. And I beg also to question, ask again, and I also ask this court, ask itself, when did the charges against the applicants, when were they filed before this court? When did this court first interact or come into contact with the applicants as a civil justice court? It is simple mathematics. It is on the 21st of February 2025. And that translates, what does that mean? Lawyers are not good mathematicians, they do not count money, but I try to count. The applicants have been in custody for 3 months and 8 days. So they have been, before, they have been on demand not more than 4 months. To put it that way, generally. Now, if that is the issue, if it is true they have been on remand for not more than 6 months, are they entitled to the provisions under Article 23, Clause 6C? The answer, Your Worship, is the negative. No. And if that is the issue, the other question is, was this a misinterpretation of the provisions of that article by the defense? We urge this court to answer it in affirmative. Your Worship, we do appreciate the provisions of that article, and we would have no problem court releasing the applicants if they had blocked the mandatory period. But they have not. This court would have assumed the jurisdiction which is over and above that it has in the civil justice system. My brothers quoted several authorities in that regard. They quoted so many cases. It is a submission that prosecution agrees with the defense that this court is by law supposed to protect all the rights of the applicants before it. But court should not also have this matter handled automatically as it was submitted by my colleagues under Article 126 of the Constitution. Even if the applicants, for example, if I'm to play a devil's advocate role, even if the applicants had blocked mandatory, prosecution duly noticed, put the defense, the applicants on notice that they are ready to commit the applicants. Be on notice. That mere notice ties up the hands of this court. It is our submission. That ties up. And any decision which is to the contrary would be administering substantial justice on a matter of technicality. How? Because the defense submitted that Article 23, Clause 6C applies instantly, and that court cannot do anything else for as long as this person or the applicant blocks mandatory period. Our argument is that even if they had blocked mandatory period, the mere fact that we put them on notice that our committee papers are ready, the provisions under Article 23 Clause 6C is not a ticket to have the applicants released on mandatory bail when the committee papers are available. Because the issue then is, what is the substantive justice here? The substantive justice here is to have an expeditious trial of the applicants which can only be done after being committed to high court. The argument by defense that, the first thing we have to do is to consider mandatory bail, let the applicants be released on mandatory bail, then the rest come later. That is thinking selfishly. It is acting contrary to Article 126.6.2e, which is important. They took a lot of time. In fact, I'm just about to take a second. So it is a submission, Your Worship, that this court disregards and dismisses the application by defense on the basis that this court has no control over matters before general court martial. They have not locked mandatory period of time. The fact that they were remanded on the 21st of February 2025. Because this application, Your Worship, is in bad faith. It is in bad faith, especially given that the committee papers are available. We are ready to commit. We have been on record several times, and we have submitted that defense has been unfisted in prosecution. Today, the prosecution of this matter, by using all the tricks available, all tricks that are actually at their disposal to ensure that they frustrate the process. They should have been the people who should be agitating for an expeditious trial. But now they are speaking the other language. Because as prosecution, we believe that now that our committee papers are ready, it doesn't make sense to have the applicants released on the mandatory. It is a prayer that these persons or the applicants be committed and have the matter expeditiously tried. Because we are ready. We invite this court to dismiss the application. They are tainted with that in this application. So,
one of the things is when does the period of remand count? And I'll start by giving the court an authority which was determined in April this year by Justice Isaac Wata. This is application number 133 of 2025, arising from criminal number UPDF GCM 022 of 2020. Besigye Hajji, applicant versus Uganda. And in this case, I will not go to the details, but I'll come to the end of it, where the court says, I find that the applicant has satisfied the requirements for mandatory bail under Article 23(6)(c) of the Constitution, Section 15(2) of the Trial on Indictments, his detention of over 1,500 days without trial, and committal qualifies him to be released on mandatory bail. This person, the 1,500 days being referred to, is the remand in the general court, in the court matter. So this authority sorts out the matter of whether the period of remand in the court martial counts. Number two, it would be absurd to construe the period of remand as 3 months. And I'm urging this court to take judicial notice because these matters have been very public. Since the judgment of the Supreme Court on the 31st of January this year, the A1, A2 have been in court applying for bail, and the prosecution has refused to concede to bail. They were not released by the authorities even after the judgment. How then can the court take the period of remand under the general court martial decided before we came before this court, under what warrants were they being held? Was a state to the order of the state, which continues to oppose bail application? My friend cannot appropriate and reprobate. He must decide what his submissions are, but not one time to oppose bail and say they are lawfully held, and then to come and disown the period for which they were retained as an extension of the proceedings in the general court martial. In fact, doing so is admitting malice, because if there was no connection, then the Attorney General would have been the first to say, release them, we are now doing new investigations. The Attorney General did not do that. So the submissions of my colleague, the prosecutor, is actually borders on admitting malice on part of the Attorney General. The court should not be caught in this conspiracy to deny the accused persons their liberty. I don't want to go back to Article 23 because it's very clear. It doesn't say the High Court only. It says, see, she says, in the case of an offense which is tried by the High Court as well as by the subordinate court, these committal proceedings are part of the trial. So the subordinate court initiates, and the High Court continues with the trial after committal. If that person has been remanded in custody for a period of 60 days, so if it was base court, it would have come for bail earlier. But because it's both, if you look at C, it's both the subordinate court and the High Court. They've been in custody for over 180 days. And it's very clear that if before the case is committed, and exactly that is where we are. We are applying for bail before the case is committed. Are we entitled to do that? Yes. And that's where we refer you to the Magistrates Court, Section 76. We are not doing it just because we dreamt of it. It's the law. It's written in black and white that in respect, this is 76B. 76B. A. In respect of any offense punishable by death, if for a continuous period exceeding 180 days, which is where we are, if you allow me not to read B, to go straight, the magistrate before whom the accused person first appears after the expiration of the relevant period shall release him or her on bail, shall, on their own cognizance, notwithstanding that he or she is accused of the offense. So before any other act, before any other application, including the committal, and we were not aware of the committal, we came for our bail application today, and we are becoming aware. So if the court were to look at who has been delaying, we were at the court martial for several months. They never commenced the trial. We've been before the civil courts for the whole of February, March, the whole of April, and this is the end of May, 4 months. Who has held the prosecution from concluding? It cannot come and infer improper motive on us. Your Honor, there is very little room left for you to let. There is no discretion in this matter.
My colleague has something to join this career, so that we are organized and I'm coming back.
For to clarify on the authority that was shared, that has been submitted to my senior counsel, Martha Karua, under which the High Court released person, this April on 17th of April 2025, on bail, the person had been remanded by the court martial, as it then was, for 1,500 days, that is 4 years. The court was presented with the same argument as has been presented here, that days of the court martial should not count. And my Lord, Your Worship, the court in debunking that argument used section 17 as then was. Your Worship, that section is the equivalent of section 9 of the Magistrates Courts Act, under which this court is set up. And Your Worship, for clarity, I will read verbatim. Right, Your Worship. Right, Your Worship. It says, the jurisdiction of the magistrate's court shall, subject to this act, and any other law limiting or otherwise relating to the jurisdiction of that court or the presiding magistrate, be exercised in conformity with the law with which the High Court is required to conform in exercising its jurisdiction by the Judicature Act. Your Worship, Section 17(2) provides for the inherent powers of the High Court. And this section is telling you that you have the same power. Your Worship, in applying that section, the judge here said, Your Worship, again I will read for clarity. At page 5, Your Worship, of course of time I will rush. That is paragraph 4. The court said, where a civilian was initially charged in the former court martial, any subsequent bail application falls within the jurisdiction of the ordinary courts, and an accused is at liberty to exercise that right to apply for bail. Your Worship, I don't know what counsel was serving with this authority. Your Worship, meaning this application is properly before you. Where else do you want us to apply? In the court martial? And Your Worship, at the conclusion as was read by my learned senior, Your Worship, it is paragraph 4 of that judgment on page 5, the ruling. After that finding, the court went on to find that all the 1,500 days spent on remand on account of the court martial were actually days that are counted. And the court counted them and released the person on bail. So Your Worship, being the position now of the law being, you cannot say that proceedings of the court martial are not counted. In any case, Your Worship, this is what, if you rule like that, this is what you're going to see. That the people who are serving time now in the prison, because of the court martial, are actually free. We would be glad to take that finding. But that is the extent of what you're saying, that whatever they are serving is not counted. So let them be released. In any case, Your Worship, as my colleague was arguing, where did the state pick the accused persons to bring them here? Did they pick them from their homes? Did they pick them from their workplaces? They picked them from Luzira government prison. They are serving time on account of the court martial. So Your Worship, again, as we close, so that I see the front of my learning scene, that time is as good as time that they have spent when they came here. So Your Worship, as I close, that is the submission of the court. I seek the court to take direction and submission.
Your Worship, the issue of the 80 days has been tackled extensively by my colleagues. 180 days. I just wish to reiterate that Land Council for the State, Mr. Billy Mumbuka, conceded when he said that he would have no problem with their being released if the 180 days are met. In his view, the 180 days should start when the accused person was brought before this court. Your Worship, my colleagues have cited authority to show that indeed the courts of law have found that the remand period where there have been a court-martial intervention start from the time of remand by the court-martial. On that basis, and what on his own concession, the accused persons should be entitled. We take it that his submission and his concession was based on circumstances where he was not alive to that decision, but it clears him lest he's taken allowed after. He said, I have no problem if they have clocked the mandatory period, but they have not, because he said it's the magistrate's court, but that decision has been cured by a higher court. The second one, my learned friend, Mr. Billy Bumbuka, alleged that the DPP brought new charges. He did so in an attempt to nullify the custodial condition in which the accused persons are placed. Your Worship, under the Evidence Act, we are alive to the fact that the court takes judicial notice of documents of the court record. Your Worship, in the criminal application number 1 of 2025, I'm referring, my colleague is unhappy, but I'm referring to that notice of motion which, Your Worship, was endorsed by the Chief Magistrate. So it was owned by the court. It is a court record. But did I submit it? I request that he listens to you. And if I may just, Your Worship, put the matter in proper perspective, the application was brought at the instance of the land chief state attorney and was pursuing this application with vigor. So he's alive with this application. It's an application to access, and he brought it up. Your Worship, that notice of motion, as it should be, is supported by an affidavit of BIP or Dick Benedict. I would want to refer to the first 4 paragraphs.
But Your Worship, I think this is the way. I know what has been approval with prosecution. I know that, Your Worship. But again, as prosecution, we cannot see when there's something wrong or wrong. First of all, we never responded to anything in this conduct of prosecution in our response. I believe that my senior colleagues will be making a rejoinder on the specific issues which we raised in our response. Yes, that was not part of it. Secondly, he's raising other issues. He's now going into details of the evidence, which was never part of our response. Your Worship, I respect my senior colleague. Do you understand? I do respect that, but being senior is not a prerequisite to go into details which were never brought up at any point during the trial. I never talked about it. I pray that this court prevails over him to speak and submit and address other matters which arose in the reply.
Your Worship, if I may, I am responding to the contention of the DPP having brought new charges.
Okay, so you took yourself.
Absolutely. Yes. And I'm mindful of the fact that, again, the affidavit my colleague is objecting to wantonly was done by the DPP. It states as follows, my Lord, Your Worship, in paragraph 2. Yes, I'm just referring to my Lord, it says that the respondents are accused persons in a criminal court number 8 of 2025, which is the number of the respondents were previously charged before the General Court Martial at Machinge and were being tried there. However, following the change of the Supreme Court in Constitutional Appeal number 2 of 2021, Attorney General versus Michael Kabasuluka, the case was transferred to the Uganda Police. The Uganda Police took over investigations of the case on 11th Feb, and I was one of the officers who was assigned to investigate the case. The case was transferred. It is in the affidavit. Your Worship, when you transfer, let's be practical. Your Worship, if you transferred your car to me, I inherit it. God forbid. So, there are no fresh charges. As a matter of fact, and my learned friend referred to the Supreme Court decision. The Supreme Court decision actually directed that the files be transferred. It did not direct that those charges be dropped and fresh charges brought. So it is coming as a transfer. It means that the process is continuous. He cannot allege that these are new charges. A transfer, incidentally, and I read from my colleague notes, is a simple English word, not a big one. The matter acquires a new conductor. We had the conductor in the General Court Martial. Now we have the conductor, fortunately, unfortunately, who is Mr. Billy. It was a transfer. The other one, indeed. Your Worship, in trying to disparage that article, he said it's not applicable because of the charges. One of the charges against the accused persons in the General Court Martial was the offense of treachery, which under Section 129 of the UPDF Act, the penalty is death. Applying it, I don't know the Latin word where I should be mutantis, but transferring it means that it is an offense because of the penalty, which cannot be tried by a magistrate court. It can only be tried by the High Court. And what should be remembered that before the decision of the Supreme Court, the General Court Martial insisted that it was equivalent to the High Court, i.e., it was the High Court of military law. Only that now it was charging civilians. It is therefore a lame argument for my colleague to contend that because it says High Court only, and referring to that Section 9, this court is bound not to be mechanical in approach. If a court, an offense in any other court has a penalty of death, it means that if it is transferred to the civilian dispensation, it can only go to the High Court. It therefore becomes an offense which can only be tried by the High Court in its original jurisdiction. As I wind up, Your Worship, my Lord, Your Worship, Mr. Billy Bunduka tried to convince you not to refer to what we have said because the record of the GCM was not here. But in his opening remarks, he said that the accused persons were arrested in November and arraigned in the GCM. He did not furnish a copy of the record to support his allegation. So I don't know whether his submission is gathered from the sky or whether it should only be taken when he submitted. It is not denied, and my worship is in the affidavit which he responded to. In paragraph 3, the affidavit of Prosecution, which hasn't studied, that in fact they were taken captive on the 16th of October and produced in paragraph 4 in the GCM on the 20th of November. Applying the decision of Mr. Justice Mwata, the period of remand then starts to run from the 20th of November 2024. Your Worship, again, my colleague referred to Article 26.3 not being applicable on the premise that the committal papers were ready. The plain reading of Article 23.6 says before committal. It doesn't say before availability of committal papers. So again, my colleague Mr. Billy Bumbuka knowingly is trying to read into the Constitution things, not even they are not things which don't exist. The clause is very specific, and incidentally, the release of the accused persons on mandatory bail does not stop the committal, because they can be committed while they are on mandatory bail. So there will be nothing to stop this court from releasing them on mandatory bail, as they are now entitled to, and then they return to court with directions for committal. And Your Worship, that can be one of the conditions. We release you today, return tomorrow for committal. It is within your power. It is not within the wishes of Mr. Billy or the state. Your Worship, I conclude, because sister and brother magistrates have declined to grant this order. They have shied away on the basis of matters being of the capital nature. Others have shied away on the basis of fear of what will happen if accused persons rightly entitled to mandatory bail are released. Your Worship, decisions of this nature in these times can be challenging, but that is why we are in a court of law. It is the reason why disputes, however outrageous, however grave, however serious, are brought to the court of law, which is independent and which is free from influence and free from fear. Your Worship, we cite in the Journal of the Discipline of Law by Lord Denning. Your Worship, it states this, I'll just read it. Just to comfort the court that despite the circumstances, it is bound to exercise its duty. That if the powerful still abuse their powers without restraint, it is thanks to the dominant influence of timorous souls. Timorous souls, my Your Worship, speaking to judicial officers or courts who shy away, exercise the power granted by them granted to them by the Constitution because of fear. Bold spirits will not let such abuse stand. Any rule of law which impairs the doing of justice, they will do all they can legitimately do to avoid that rule. They will even change it so that justice before them is done. We therefore appeal to this court. The Constitution commands the court to release the accused persons on mandatory bail because they have met the standard, subject to the conditions which the court rules. That circumstances are dire and perhaps strange things will happen, that is an after event. The role of the state, as I conclude, Your Worship, was very simple. Under Section 76, the duty of the state, this ability by my brother, was to demonstrate with it. They are entitled to be released unless, before the expiration of that period, they have been committed. In this case, there is no committal and he has conceded. He has his papers ready, perhaps in his court, but has not done the court. Two, the magistrate is satisfied that it is expedient for the prosecution of the public that the accused person should not be released from custody. We have not demonstrated anywhere that these are a danger to the public. He has not therefore discharged his burden in any way, despite the time court accorded him. In any event, your brother magistrate allowed the public to interact with the accused persons and they were not endangered. To the extent that Mr. Rivulka has not done anything to dispel or to prove his guilty, it is our prayer that the inevitable must happen, that the accused persons are released on mandatory bail, subject to the conditions which the court shall fix. Your Worship, in vain your indulgence, my colleague calls the firm that there's something they haven't covered, just to accord him 1 or 2 minutes to cover it. He has stood up and says he has been piercing me to say there's something like this. I apologize.
Just 1 minute.
Much obliged, Your Worship. Your Worship, all matters have been canvassed. I just want to add in reply to Mr. Billy Mumbuka's contention that states are ready to commit, and therefore it should be reasoned as to why the court should not admit the applicants on bail.
I think it should be very clear, otherwise you have nothing to say. My argument was clear.
So let him submit and then
Your Worship, the authority I would want to cite to this honorable court is a high court authority. Yes, Your Worship, because it's instructive. It's instructive on the issue of Your Worship, if I may, it's instructive. The authority is instructive, and I came here on this submit an authority report. It's instructive on the issue of the prosecution being ready to commit amidst a bail application, a mandatory bail application. And this authority by Justice Collins Asley at the High Court of Bull, where the persons were charged with aggregated robbery, stated that even if, because prosecution was requesting that it commits before the mandatory bail application is had, the learned justice had an occasion to say that even if the prosecution had papers in court, as they had then, you cannot overlook the provisions of the Constitution for entertaining and granting an application for mandatory bail, and therefore it can be done later.
Subscribe to the channel.
For its of binding nature to this honorable court, for it is a high court authority, and the authority is Andrea Charles and others versus Uganda, miscellaneous criminal application number 3 of 2024 at the High Court sitting in Arua. Your Worship, we shall provide the authority. My friend has stepped out to bring the same, and court admitted the applicants on bail, even when prosecution had papers in court saying that it was ready to commit the applicants. Much obliged.
Your Worship, we shall use less than 2 minutes. And in these 2 minutes, granted last year, we shall instead characterize the submissions of Richard Pilgrim and those that suffer from lack of focus and clarity And also outrightly, we associate the submissions of Islamic Council, Papa Karua, and Frederick Chupanga, and the other councils.
With the leave of court. If the court is the
We are going for a court ruling about the bail application. We are going for a court ruling about the bail application. Share the live, share the live. Subscribe, like, and comment. The judge is going to give a ruling. The judge is going to give a ruling. The judge is going to give a ruling. Subscribe, like, and comment. This is the Heavy Media. This is the Heavy Media. This is the Heavy Media. Subscribe, like, and comment. The court, the judge is going to give a ruling about the judge is going to give a ruling on a bail application of today. So the judge is going to give a ruling. The judge is going to give a ruling right now, a few minutes from now. The judge is going to give a ruling. The judge is going to give a ruling. Omuyita n'azanyira mu kamera yange todda mumuyita aleeta face nze kiri si kifeesi feesi nze kale nina kifeesi nange nkimanyi agala banteeke Besigye waali. The judge is coming with a ruling. The judge is coming with a ruling. This is how the court is. It is right now. This is how the court is right now. The judge is going to give a ruling on the application of Dr. Kizza a few minutes from now. The judge is not supposed to be shown. Those are the rules of this court. You want me to join Dr. Kizza, my brother? The judge is not supposed to be shown. If you want to see the judge, you come at Nakawa court, you're going to see her. Otherwise, the judge is not allowed to be shown in the cameras. The judge is not allowed to be shown in the cameras. If you want to see the judge, come to Nakawa. Okay, let's make 400. Ngezeko Balaka judge. Let's make 500. Share the live, we make 500 viewers. Balaka judge, Kali. Share the live. Ngina mnya mateka Justin aita chikizibwa. Abagala menya mateka mbalaba bambuza where is the judge? Where is the judge bagambye bawere bitaano omumenya amateeka naye bagambye sobola okukanga mu eddakiika emu be bati bali kulayo ne bwoba ompa ssente jjaji sisobola mukulaga muganda wange ne bwoba ompa akakadde siina jjaji jangu enakawa omulabe abagala olaba jjaji ntegedde temunjagala wallahi yogera ku mukono wange sijabasobola mmwe the judge is not supposed to be kastondaba
kitumalako emirembe
nga kisaba ebifaananyi kyana ekyo kati kiba kikijja leeti
kasita mukamaawo
nabayo meseji yammwe mwe abasirikale balikulayo babadde babawulira according to the defense into hiyo the doctor nawe omusajja nkwata mutwe gwe omusajja ekifaananyi yange kyeyalikoze singa ndi wano bwenti kati naye waliwo omutwe gwe okulaba breaking news. Breaking news. Akanaka wakati. Balo yawa. Olandabisemu kijja kunyuma ebifaananyi amina kandabiseemu kumbi ne kwerima anytime from now we are getting the ruling of the judge. Yes, anytime from now we are getting the ruling of the judge. Subscribe. If you have I don't need NBS, my brother. Sina jendi nawe bampa omulimu nga bampa $5,000,000 sikola ku NBS. Amagwa gwe Ronald wamagwa otegeera kubanga toyinza kuŋŋamba mbu nkulaga ejjaaji kugambye the judge is not supposed to be shown. Ye jjaaji oyagala waaki oyagala mukwana omwagaza ki jangu enakawa come to Nakawa my brothers. Alma, hi. Lena, how are you doing? I'm hearing your voice here on the YouTube. Wow, who's that? Who's that? Oje. You've ever seen something? Anaki. It is the Heaven Media. Subscribe, like, and comment. We are waiting for the ruling of the bail application right here in the court of the Magistrate Court of Nakawa, and we are live at Nakawa. Abafe. Abalero. Eno live nzindikiza kooti mashu. Badendo awakuba. The number is on the DP. Again, I'm on DPR channel. Over Secho. But we got the number 0787. Yeah, 0787 103 103 136. For those of you who want the number, 0787 103 136.
Number 10.3 of the guidelines provides that for avoidance of doubt, mandatory release on bail for offences triable by the High Court, the Constitution, and Article 23.6 of the Constitution shall be granted only by the High Court. This provision outs the jurisdiction of this court which grants the applicants mandatory bail. The fact that this court's jurisdiction is ousted by the practice direction number 10.3, this court cannot go ahead to determine whether the days on remand cover the period before the accused were arraigned before this court. I wish to also add that all the authorities cited by the defense are authorities of the High Court, which granted mandatory bail in capital offences, which is well within its jurisdiction as per the bail guidelines. For the above reasons, this court lacks the jurisdiction to grant the applicant's application for mandatory bail. The applicants can apply to the High Court for mandatory bail.
Your Worship,
cited Legend 10, Legend 11 says that once you do that, then 11 says that you immediately transfer the file to the High Court. I pray that you abide that guideline and include the pardon? Yes, this is the guideline that what is using. So I would want to read it. The procedure for bail, that is the heading. Magistrates court shall submit to the High Court files of persons eligible for mandatory bail. Subsection 2, an application for mandatory bail in the High Court. So basically that is subsection 3 of section sub-headline 3 of guideline 11. It says that this court submits people for mandatory bail.
Your Worship, joining this, again citing those guidelines, because those guidelines, just to put it, create a link, provides that an application for mandatory bail in a court of this nature will be oral. We have made no application. The court has found, as it did, that it does not have it. It has not found that the accused persons do not qualify, meaning that the matter now, the issue, is about. Therefore, I'm relying on the same regulation or guideline. 3 reads, the magistrate court shall submit to the High Court files of persons eligible for mandatory bail, and upon receipt, the register shall cause the files be registered in the bail register. To that extent, and guided by the first sub-regulation, which provides that applications in the magistrate are oral. Ours is an oral application now, given the filing of court, for the file to be forwarded to the High Court, which is a command to the registrar to enter it in the bail register so that that application is. It appears to be mandatory and not discretionary, so we reckon that once it's been referred to the court, it is bound to abide. I reckon that the response from Mr. Bill will be to affirm the mandatory command so that going forward, the file proceeds.
Much obliged, Your Worship. Then it should be on record.
That is a critique. That is a critique of the ruling which you are not prepared to do.
It is
You
fine.
don't have it on record now. That's a wrong
Just something.
Your Worship, we pray that court makes him on record. Because we are now starting to
Make a submission.
Your Worship, it is on record that we filed a bail application in the High Court. Your Worship, the bail guidelines under specifically guideline number 8, provide for time to dispose of the bail application. Your Worship, it's now 1.5 months, which is over 30 days. Yet in the bail guidelines, they clearly state that a bail application shall be disposed of within 30 days upon its filing. Your Worship, up to now, our bail application we filed has not been fixed or even heard. Now, what we want to be on record is that in this ruling, or in this trial, in this case, there has been selective application of the guidelines that we are using in bail. Because if this court is applying them to say that we must go to the High Court, but the High Court where we are is not fixing our application within 30 days as mandated by the guidelines. We submit that that is a clear and clear selective application of the guidelines. And my Daniel brothers now can come in emphatically to say what he wants to speak.
Your Worship, Kizza and Council, we go to 10.2. I shall read. In the case of a person who has been on remand for 180 days in accordance with Article 236C of the Constitution, the magistrate court shall immediately refer the file to the High Court. My Lord, Your Worship, let's have a prayer that the file be referred to the High Court.
Again, this is a report of interpretation of the provisions that my colleagues are relying on. One, for a magistrate to refer a matter to High Court in case of mandatory bail, that court must have pronounced itself on the fact that the applicant or the accused person has clocked mandatory bail in custody, which is not the case in this regard. It is not a duty of this court to pave way for the release of the applicants. The applicant has a fleet of senior lawyers who can move High Court in this regard. There is no basis for this court to refer this matter to the High Court because they have not, the applicants have not clocked mandatory period in custody. You cannot have a matter in February and then in May you say the applicant has clocked mandatory. It is simple mathematics. This court has no jurisdiction. In other words, that application is misplaced. If the applicants wish to make an application before High Court, they can do it on their own initiative, not through the vehicle of court. That court should move them. And it's not, by the way, it's not the fault of you, Your Worship, that the application which my brother Bayan has been submitting upon has not been fixed. Therefore, I don't want to use a harsh word. I want to use it. But if we meet, that's what you are giving them a lot of time. But when it comes to me, you give me one thing. What are we? This request is misplaced. They know where to go in case they want the application to be fixed. In summary, Your Worship, I pray that you dismiss that application and we proceed. We proceed with the amendment of the charge sheet and other processes for today, as prosecution shall actually address court.
Again, a brief rejoinder. We have cited the guidelines. We cited the requirement of the court to submit the file. Unlike my colleague, Mr. Philip Mbuka, court did not say that the 180 days period has not been met. But Your Worship, catching from 3, where a magistrate shall submit to the High Court files of persons eligible for military bail, and upon receipt of the evidence shall cause the files to be registered in the bail register. 4 says the register shall list the files submitted under subparagraph 3 for hearing by the judge. 5, which is very important, says upon disposal of the bail application, whereby it may be granted or it may not be, the file shall then be returned to the magistrate's court to enable the court to proceed with the commitment. It means that once you applied for bail and the court has found as it has, as a matter of the High Court, once you have applied, in fact, Regulation 3 doesn't require that you apply, it requires that the court forwards the file. It means that because it is the right of the accused, all other proceedings stop until the matter of mandatory bail is handled. So again, the words in that resolution do not say may. It is shall. As lawyers and advocates who appear at the bar, we are enjoined to be official court. We are praying, Your Worship, that you do not allow Mr. Billy to mislead court. So, we are therefore saying that the command is that the file be forwarded. We also refer to the same regulations, which is case Regulation 10, sub-rule 2. A person who has been on remand, which my colleague referred to, more than 1 days, the magistrate shall immediately refer the file. Mr. Bilmuka will have his day in court to make all the healthy submissions. We are saying that this court, its ruling, now does not have any matter to deal with this one. Let us go. We shall return when that matter happens. And perhaps to add, we are certain that when we go away for a bit, it will allow this court some respite. So we pray that we go to the High Court to determine that right which cannot be abrogated. Then we shall come back when the court has pronounced itself.
One point. We appreciate your ruling, although we were of a different mind. But now that the court has decided to adhere to the guidelines, we are asking the court to be consistent and therefore in line with guideline number 10.2, as urged by my colleague, to immediately refer the file. It would be quite untidy if the court was to adhere to the guideline and then not adhere to the guideline. So for the sake of consistency, predictability, and the appearance of justice being done equally across the board, let this file go to the High Court.
Yes, I see. It is very important. It is very important.
I have what I got. Let me make my
Take it, David.
Wabula kyewankoze
omanyi olumbe tusula mu nsiisira nga tugenze mu lumbe olumba tugirekawo
abantu baba bazze kubalaba
olutalo bali wabba abantu
omulaba leero kyokoze ng'oyimiridde wano nange eva bwebwabeera wano kyabadde nga nkola naye leero am happy that
naye bw'oba ne kadi mukaaga wano
kadi ki
kansirikire bangeme ebifaananyi
vidiyo zembeera nkwata ziba zigenda ku twitter
antogera ne kadi nga mukaaga
anti
vidiyo ziba zigenda
kutagira kamera amenya ku twitter
ate gamba wonamuteekerayo ku twitter ng'otose ku ssaawa 8 nga koti yatandise ssaawa 3
omwana musala resolution
olabye wekifiiringa oddanga
obedde era mugamba simukuba ngolo
balabye ku nkoona yange abantu
obedde abagira
gwenookola naye ono
amina
nakabaringa essimu yonna
balina okimanya gye tujja footage omuwazibu
golaba omutwe gwange gunkana n'obugwe
okimanyi nti tracking shot bwe bateri mu kukankana tenyuma okwata shot yatira gaasi bwe batekankana tenyuma
tracking shot sawa yakugaba ruling ku nsonga zino zebadde basubmitinga bail application yo erabika nga yagaaniddwa era aba defense councils basaba bail application egende oba okusaba kwa bail application kugende mu kooti enkulu mu Kampala. So tukyali wano Nakawa, wano ku Nakawa Magistrate Court mu maaso g'omulamuzi tuchagendera ddala mu maaso. Just in case you are following up, subscribe, like and comment. Oyo gwolaba ye Dr. Kizza Besigye. Ensonga zonna ate tukyatambulira ddala, ogenda banga ofuna ddala buli kimu okuva gye twatandikidde abakyalinaffe. Thank you very much. Oli ku Heavy Media.
Considering the prosecution intends to amend the charges and make other proceedings thereto, prosecution should proceed with the application for amendments to the charge sheet.
Question before my colleagues. Our instructions are to seek a revision of that order.
It is well. The revision will be made, but for now, it was.
I know that when we ask for a revision, because the decision will continue after our revision has been invested, not the subject of the revision, it is not proper for the court to continue the trial. Our position is strengthened by the Supreme Court decision the import of this decision is that when a process in the lower court is under challenge in the higher court, the lower court must wait lest it proceeds and the decision or procedure is found to be faulty in the critics. So our request because we have sought a revision under the Criminal Procedure Code, we are referring to 848. We are asking the court to review the file, including the decision regarding bail, mandatory bail. Yes. But we are going to apply for revision. We are applying for revision. So we shall be requesting the court, the higher court, to review the proceedings in this court. To satisfy itself as to the correctness, the legality, and propriety of its finding. So to the extent that we are testing court regarding the legality, the propriety, and the correctness of your finding, we beseech you to stop so that the file goes and checks the correctness of what we are doing. Your Worship, because we are told that we are submitting decisions of the High Court, in the application, criminal application number 1 of 2025, the very one we are referring to Uganda versus Kano Kizza Besigye and others, that is what happened. When the court made a decision regarding the cross-examination of the deponent, whether it be in public or in a closed court, and we sought a review, the court stopped henceforth and deferred the file to the High Court. It is our same prayer. Circumstances are the same. We are praying that you allow, most humbly, Your Worship, to submit your proceedings to the higher court for correction. It is the request of the accused persons. They feel it is their right, and we should allow Your Worship to submit your proceedings to the high court, as indeed.
Just to remind this court that this court has already made a decision, brother judge, when there was challenge about access to the courts and the matter went to revision, the court halted that application pending the revision. For the sake of consistency, this court ought to agree to halt the proceedings until the revision is done. And I will repeat what I said in the beginning. Justice is about should be done, but also must seem manifestly to be done. And we should have equality of arms. It should not look like the court, the scale is dropping on the side of the prosecution. We want bail, which is mandatory. We are now asking that matter be prosecuted fast, and not the prosecution's hurry for committal when there is mandatory provisions for bail. So kindly, let us go on revision, let us test the revision.
Lordship, for the record, Lordship, still referring to the same matter that of the criminal misdemeanors application which was submitted for revision. From section 48, we are supposed to go to the High Court asking for the file. So essentially, we can't ask the High Court while we are here, as it is now. Although our instructions are, we go to the High Court and ask. So what is essentially what we are asking for, and what your learned sister, our worship, Nyadoe did. She adjourned the matter, gave us, actually it was 30 days. We went to the High Court, asked the High Court, and the High Court called the file, and the revision is there. So actually, essentially what we are saying, that the court should adjourn this matter, allow us to move out, go to the High Court, ask the court to call the proceedings so that we can go and handle the revision there. Otherwise, we can't ask the High Court to call the file when we are sitting here.
You may wonder what we are
requested is a stay of this proceeding because there are two reasons, there are a number of reasons, but one of them is that under Section 17 of the Education Act, this honorable court is subject to the supervision of the High Court. And under subsection 2 of Section 17, paragraph C, the High Court has to ensure that the substantive justice is done, just like we are enjoined by Article 126 of the Constitution. That cannot happen, Your Honor, if you continue with the proceedings that the Constitution wants to bring to bear without giving High Court a chance to look at the record of today and entertain our technical and legal objection to the way that this court has, although it is obliged, calculated the remand period, refused. That's one of the issues which have been taken later. So one of the questions for High Court is a magistrate empowered to decline to calculate remand days from 20th November last year to today? Is the magistrate legally in law, not in caprice, is the magistrate in law, not caprice, entitled to decline to calculate mathematically the days that an accused person or each person has spent on remand? Our opinion is that is parliamentary and constitutional of that magistrate. We want the High Court to intervene, and it cannot intervene unless this court allows it. Because the point of mandatory bail, I would like to be on Your Honor, the point of mandatory bail is to ensure the personal liberty of the accused. It is not something made perfunctory. It is made so that life and meaning is given to the presumption of innocence, among other reasons. So this is a matter concerning fundamental human rights and freedoms of the accused person. So in making this application, pursuant to the provisions, my grand colleague has to Section 17 of the Education Act and the other provisions, is that we are trying to go to High Court to cry out to the High Court and say that the person the bail guidance told to calculate days has refused and has said so in writing that I have not counted the days. What is stopping her? The state will explain. Why is she refusing to count the days of the man? Yet the road does not even give her the option not to. Those are some of the questions that have been taken. Thank you very much. The application that first is seeking this court, one, to stop the proceedings before it. Two, refer the matter to High Court for revision. Because they want the High Court to find out whether the proceedings are in line with the procedure. The defense
cited a matter which is before you land it. For whom the alleged say stopped the proceedings and referred the matter to High Court for revision. What is the law on revision? That is what we should begin from. Revision is provided under Section 48 of the Criminal Procedure Code Act. Cap 122. Those of Uganda. Revision is a preserve of the High Court. And the procedure is the defense make an application in the High Court. They make the application in the High Court. And then High Court, if deems it necessary or fit, calls for the record from the lower court. It is not anywhere in the law under section 48 and 50 of the Criminal Procedure Code Act that it is provided that the magistrate or the lower court who is in personal conduct of the matter under dispute is by law supposed to A, stop the proceedings, refer the matter, and send the record of proceedings to the High Court. It is not. The defense are using a completely different procedure altogether. It is the High Court instead which is supposed to call this record if it deems it necessary. And this court is you don't oblige at any point to stop the proceedings in this matter because there is nothing wrong on the record. And by the way, there is no provision that the defense has to lay out the reasons as to why they are seeking the revision. Whether you have 100 reasons, that is your own. You can only do that when you're seeking a constitutional redress, not in a revision. So the procedure they adopted is completely, that is regular. It is misplaced for want of a better one, for lack of a better one. The defense submitted that your colleague, when faced with such an application,
when we are before you, so essentially it's an adjournment to make the revision application so that our client can exercise their rights. We do not want to proceed, and then the court says it's an application so that so that may be the revision application will be prepared and filed. Otherwise, we cannot be in two places at the same time. We are going to seek that application because we don't need permission of the court. Thank you. And so we are requesting you that you court bears that in mind, because after all, we are going to review what has happened, test the legality, propriety, and others. So simple. We believe, like I said, that common sense will require that we stop here. The High Court guides us. We come. We are not running away from it. We shall come. We are saying we want it to be done. We don't want to proceed, yet we are reviewing, so that we have that's the simple. And I'm sure Mr. Bill will people knows, because even in that case, we argued a lot, but eventually so the it. So we asked him to see light earlier, so that we don't proceed. It normally takes long to see this thing.
No, Your Honor, these are very serious matters. First of all, I think my brother misunderstood the scope of application. It's not just a revision application. This is also an application for supervision. And as I kept saying that in fact here, it is also premised on Section 17 of the Educator Act. You all logically, it will serve no purpose for us to proceed to the High Court if you proceed with today's proceedings by the prayers of the Prosecution. In other words, you will be indirectly telling us that you don't go to High Court, because there will be no purpose of going to High Court if you are going to hear committal proceeding. It is both illogical but also illegally and conscionable to entertain committal proceedings whose net effect is to frustrate the mandatory bail of accused persons. In law, it is called abuse of the process of law. If a magistrate conducts court in such a way that when the prosecution senses that the mandatory bail application has been triggered or is looming, to ensure that there is a committal so that the accused persons do not successfully apply for mandatory bail, that is an abuse of the legal process. It is important that we be mindful of the context of this military proceeding. The accused here were not arrested in Uganda, were abducted, tortured, illegally detained in the military detention for 4 days before they were arraigned before a kangaroo military tribunal. Can I proceed? Please, maybe, what can guide us?
That's okay, sir. Don't raise.
Yes, I'm not raising issues. So Article 43 of the Constitution, and in the context that I have said, forbids political persecution. What we are seeing here, the use of committal proceedings to stop mandatory bail is a stellar example of political persecution, which is prohibited in absolute terms by Article 43 of the 1995 Constitution. A prosecutor is precluded from using his office to initiate committal proceedings so as to forestall mandatory bail. This is my opinion. I think you are not going to zip my mouth.
Just a minute, Your Worship.
That's okay, sir. Let him
I don't want to take about this. Because it's what we call, we need to proceed in a manner that actually represents what we hold up. If you hold up as a lawyer, then you present your facts and evidence as a lawyer. You cannot submit in this court and attack the office of the DPP that they are coming up and you say that the office of the DPP prepared committal papers in a bid to deny the applicant from benefiting from mandatory bail. Do you have an agreement with you? We are performing our role as DPP. So there are some things
Yes, there are some things that shouldn't be said here. Otherwise, they become too unprofessional and courteous.
Yes, I'm finishing. Subsection 5, clause 5 of Article 120 on the powers on the Office of the Director of Public Prosecution reads as follows: that in exercising his or her powers under this article, the Director of Public Prosecution shall have regard to public interest of the administration of justice, and the need to prevent the abuse of the legal process. What are we seeing here, Your Worship? A classic example of the abuse of the legal process by the Office of the Director of Public Prosecution, in his words, claiming that they have come with the committee papers so as, in my opinion, and the opinion shared by the entire legal team and the chosen persons here, to frustrate mandatory plea. We implore this honorable court to prevent that abuse of legal process, because it is also tantamount to political persecution prohibited in absolute terms by Article 43 of the Constitution. We cannot run away from the context of this matter. Thank you.
Just for a few minutes, then I come back
Genda kukola interview tuvewa. Omulamuzi Kizza kitabuse agambye agenda kudda.
Thank you so much. I think I'm not going to matter no more.
Ya lero bawa. Oyo bwati bwayogera. Sajja mugwaro. All right. Koti ewumuddemu ekiseera ekitali kigere. Koti ewumuddemu ekiseera ekitali kigere naye agenda laba oba tweyongerayo n'eno oba tukoma wano. Alakolayo just interview.
Kanza biri bumbu. Kanza biri
Kizza agenda mufuna agenda tubuulira buli kimu. Abakyaliko subscribe. Like and you better like and comment tubeerenga tukwasaganya ensonga zino. Share the live, share the link. Batugambye tukomawo okusembayo naye sisuubira nti
Thank you.